I move to introduce 696.
Objection, hearsay.
Hearsay, we already have a record, a business records affidavit, which addresses whether the reliability of it. It is not a statement. It is a suggestion to this man by a co-conspirator in this case, not a co-conspirator with him, but a co-conspirator with the Attorney General and Mr. Paul, as they keep feeding this information in pursuit of their conspiracy. That's the reason we offer it.
And therein lies the problem. Mr. Hardin suggests as they keep feeding the information. There is zero evidence that Ken Paxton saw this document, participated in this document, created this document before it was sent by Mr. Wynn to Mr. Kamek. And for Mr. Hardin to suggest there's not a statement is belied on the face of the document. Look at the very first page.
The objection is sustained.
All right, may I just for the record add one thing. Mr. Paxton doesn't have to have seen this if there's an actual conspiracy going on. It only needs to be somebody that is a member of that conspiracy, any overt actor making any statement like that. I just want that in the record, Your Honor. I certainly don't want to quarrel with you.
Yeah, we sustained it to hearsay.
All right, thank you, Judge. Now, let's move forward. You are going to issue grand jury subpoenas, were you not? I
Yes,
said
sir.
are, but you were. Is that correct?
Yes, sir.
And in preparing those grand jury subpoenas, I think we testified you used the assistance of the AG's office or the district attorney's office to get the forms prepared, correct?
That's correct.
Did anybody in the district attorney's office work with you or anything as to the content or the people they would be sent to or the wording or anything like that?
I believe I received a form from them in an email, like a sample form. That's the only thing that I received back from them as far as assistance goes.
So is what you said, what you received from them, what I'm really asking is, did any lawyer or anyone working on behalf of the content, did anybody try to talk to you about the content or the people to subpoenaed or anything like that?
No, sir.
All right. Was their duty simply aiding you to get the grand jury subpoena before a judge to sign?
Yes, sir. They facilitated
that. Did you discuss with anybody in the district attorney's office anything about who you wanted to subpoena or anything like that? Or did you simply provide them the information, they helped you with format, and presented it to a judge for you?
Yes, sir. So I just emailed the application for the subpoenas. They did not offer any assistance or make any comments or anything about the contents.
Was there anyone in the Attorney General's office aiding you at all in terms of investigating this complaint of Mr. Paul?
Objection, conjecture, and speculation.
Sustained.
All right. Now, at the end of the time, when you issue these subpoenas, let's go to the dates and times you did it.
Yes, sir.
Did you issue some subpoenas originally by email? You got your billing record up there?
Yes, sir. I'm looking at the
And your records or your memories show you when you did it? When did you first start serving these subpoenas?
Would have been September 25th.
Pardon me?
It would have been September 25th, 2020.
All right. And then after you sent, do you remember how many of those you sent out by email?
It was roughly 35 to 40, somewhere in there.
All right. And then after you sent out some by email, then did you reserve some that you were going to serve and serve personally?
I think there were a few that I was going to serve personally for the second referral.
For the second one?
Yes, sir.
So why did you decide to send email for the emails on Mr. Paul's complaint, but decide to serve personally those in the second referral?
Because can I explain myself?
Sure.
So I have this list that I'm given of individuals that are subject to either the first or second referral. I get that from Michael Wynn. And the grand jury subpoenas were going to go out for email address, like to and from, the email log, to, from, what time, around the time that this search had taken place. And then there were also phone numbers to see if any contacts had been made around that time between cell phone numbers. So I say all that to say this: most of the people who were on this list either had a Gmail account or a Hotmail or a Microsoft account. So rather than piecemeal, let me get a couple subpoenas here, there was no intention of it to be this big shock value of sending out so many subpoenas. It was like, let me get all this information together, I will go through it and then go from there. And with respect to those that I emailed out, that's the way I looked it up. I went and looked that up. Like, okay, how does Microsoft receive a subpoena? Well, you can fax or email it. With respect to the banks that I've served those subpoenas on, I just did it in person.
Well, and then you notice you sent out, did you not, on the emails you did that you were subpoenaing personal cell phones records? Did you send that out by email?
Those were by email,
Yeah.
the cell phone records.
So were you sending out subpoenas for personal phone records of law enforcement officers, state and federal?
I'd have to look back, but I believe some of them were.
And were you did you even send out subpoena for the cell phone records of somebody who worked as a deputy for a federal magistrate? A courtroom deputy?
I would have to look, I believe so.
Okay. And then you don't happen to recall on the top of your mind right now who all you did, correct?
I do not, sir.
Okay, that's all right. So then, when you send out these different subpoenas, did you have any knowledge one way or the other that some of the people that you were sending subpoenas to were opposing counsel to Mr. Paul in civil litigation? Did you know that?
No, sir.
All right. If you had known that, would you have done it?
No.
All right. Who did you get the list from as to who subpoenaed?
I got the list from Michael Wynn and Nate Paul.
So is it an accurate statement to say that you issued grand jury subpoenas on behalf of the person that was under a state charges? You issued subpoenas to his agency, the Securities Board.
Objection, assuming facts not in evidence.
Did you realize that? That's really my question. Let me rephrase
Sustain.
it. Thank you, Judge. Let me put it this way. First person out of the box in that prosecution memo we went over is Mr. Ronnie Saban, right? Did you know that?
Yes, sir.
All right. And you knew him as one of the agents involved in the search, correct?
That's correct.
Were you aware that he was an employee of the Securities Board and was involved in the criminal case where charges were filed and pending at this moment still against the Attorney General?
Objection, assume facts not in evidence.
Did you know that? That's all I'm asking.
Sustained.
Were you aware of what his role was?
Of the gentleman, I think you said Ronnie Saban?
Yes.
No, sir.
All right.
I just only knew him as one of the individuals who had searched Mr. Paul's residence.
Fine. All right. And then different other people. Did you know that Mr. Ray Chester, who was on your list, was opposing counsel in a lawsuit with the Mitty Foundation? Just did you know?
No.
All right. So did Mr. Wynn provide you these names without informing you that part of what they were seeking was information with people that were either in litigation against the Attorney General, namely the criminal charge pending, or in litigation against Mr. Paul,
Okay,
namely the
I'm
Mitty
sorry.
Foundation?
I'm
Were
sorry.
you aware of any of that?
Multifarious, assuming facts not in evidence.
It's all in evidence.
No, it's not, and it's multifarious.
We have heard, well, excuse me, let me let the court rule.
Overruled.
Thank you very much. Were you aware of that?
I'm sorry, could you please rephrase that question?
So did Mr. Wynn provide you these names without informing you that part of whatever they were seeking was information with people who were either in litigation against the Attorney General, namely the criminal charge pending, or in litigation against Mr. Paul in the Mitty Foundation litigation? Did he inform you of that?
No, sir.
Okay. Now, then you move on to the subpoenas that you were going to serve personally. And is it your testifying that those subpoenas were based on the second referral that Mr. Paul had filed originally with the DA's office on September the 23rd?
Those were for the second referral.
All
Yes,
right.
sir. Yes, sir.
And that's the referral that you had said you got on the 24th, right?
Yes, sir.
Okay. Now, at the time you sent out these subpoenas the previous week, after you sent them out and the judge signed them and they were ready to be sent out and you sent them out into the world of the internet, did you inform the Attorney General?
I did.
How did you inform him?
I believe I sent him an email.
All right. Did you send him an email at any time letting him know which people you were subpoenaing?
No.
All right.
I don't think I individually named.
You need to stay with the microphone, please.
I don't believe I individually named each person, but
All right.
I just don't recall that.
Now, when you went out to serve the subpoenas in person, what dates did you do it and how did you do it?
That would have been on September the 29th of 2020.
September the 29th?
Yes, sir.
All right. And had you made arrangements with Mr. Nguyen for him to go on these services of subpoenas with you?
So he was insistent on going.
What did he, I mean, how long had he been insistent talking to you about wanting to go with you?
Just maybe a day or so. I told them, I was informing them of what I was going to do to serve. I was going to go drop off the subpoenas, and he was insistent on going, and I was like, no, you don't really need to do that. I didn't really think it was appropriate. But he said, I'm Nate Paul's lawyer, and it's important for me to be there in case they ask you any questions about his case or anything that's going on. And so, I felt a little pressure to say, okay, and he rode along with me.
Share with us why you felt pressure to accede to that.
I think just kind of pressure to perform. I wanted to do a good job, and I frankly trusted Michael.
Right. Did he inform you there was a statute prohibiting an interested party from serving subpoenas?
I was not aware of that.
Okay. And then, so when you made arrangements to go with him, where did you first meet up?
I forgot the hotel I was staying at down here, and he was at a hotel, and I just picked him up and we went.
What day of the week was it? 28th was a Monday, was it not?
I don't know. It was September 29th.
September 29th. I don't think anybody's going to argue if I can say it was a Tuesday.
Okay.
By the way, by this time, Tuesday the 29th, how much contact did you had with the Attorney General about this investigation? How many times? Just first of all, how many times did you talk to him by phone?
Between phone calls and text messages, it had to be somewhere 15 to 20 times range over that 3.5, 4 week period.
Yeah. So that'd be 15 or 20 times that you were in contact with the Attorney General about the case, correct? And leading up to the 29th. And would you agree that you really actively get involved on the 3rd of September?
Oh, I'm sorry, one more time?
Roughly the 3rd.
The 3rd?
Yes. Remember the billing records, the first thing you billed is September 3rd.
Yes, sir, that was a typo. The date that I actually went out there was on 9/4.
All right. So can we say that those 15 to 20 times that you're in personal contact about this case with the Attorney General was 15 to 20 times in the days between the 3rd and the 29th of September?
I think that's accurate.
All right. And how many of those do you think they were personal phone calls?
I'm sorry, what?
How many of those 15 to 20 times were phone calls?
I would have to...
Roughly, just approximately.
Say maybe 7 to 10 times.
All right. How many of them were personal visits?
I didn't have any personal visits during that time.
During that time, you had the first meeting that you described when you were hired. Is that correct?
Yes, sir. I had the 8/26, the 9/4 day, and then throughout the month of September, I didn't meet any more in person.
Okay. And by the middle of it, he is communicating with you by a particular type of encrypted app. Is that right?
Mostly through cell phone text, and then I was asked to download the Signal app, and I don't think we had I don't even think we had a conversation on the Signal app, maybe. I mean, I had that and then my cell phone.
Now, did the Attorney General, did you give the Attorney General advance notice that you were going to be going out on the 29th and serving subpoenas?
Yes, sir.
Had you sent him any preliminary list of who you were serving on?
No, sir.
Had you told him approximately how many you were going to serve?
No, sir.
How many were you planning to serve?
I believe there were 4 in person. There were the banks who were kind of the ones that were being accused in that second referral of this bank fraud deal.
All right. And so the email subpoenas that you sent out had to do with Nate Paul's referral number 1? Is that correct?
The emails that I sent out?
Yes.
Yes, sir.
Those subpoenas.
Yes, sir.
And then the subpoenas you served in person had to do with referral number 2. Is that what you're saying?
Yes, sir. That's correct.
All right. And when you took, would you just tell us in your own words, recite to us how you served those subpoenas?
We went to 2 banks.
Yeah, let me stop you there just a second. In each of these banks that you went to, did you identify yourself as a special prosecutor for the Attorney General's office?
Yes, sir, I did.
All right. And Mr. Wynn was with you at each one, correct?
Yes, sir.
Did you attempt at each of these banks to do some interviews of the people you served them on?
Just talking to them, yes, sir.
Yeah.
And giving the subpoena.
And did you talk to each of these people during it, in some cases, a little bit about why you were there in terms of the case?
Yes, sir.
All right. And you were there about a case Mr. Paul contended was a mortgage fraud case, correct?
Yes, sir.
And that was a case in which he wanted you to subpoena also or investigate a federal bankruptcy judge, correct?
Yes, sir.
Okay. And then did you conduct an interview of the husband of a court deputy during one of these services of subpoena?
There was I wasn't serving a subpoena. I don't believe it was that was trying to talk to him.
All right, that was an interview without serving a subpoena. Without giving the person's name, unless counsel asked for it, and I think it's in the records, without giving the person's name, who did you go interview? Was it the husband of a deceased deputy?
Yes, I think she was a clerk of the court.
And where had the deceased clerk of the court been a clerk?
She was I forget which court it was. It was the court basically where this first initial referral came out of, the search warrant that came out of that made the basis of the first complaint.
So she was a previous clerk for the federal magistrate?
Yes.
And who were you talking to, her husband?
Her husband.
And did you have some suspicions or so that made you inquire as to how she died or anything?
I think there was I can't think of the right word, but there was like an indication that maybe there was some kind of foul play or something there with this clerk.
Now Mr. Kamak, that had been a suggestion to you by Mr. Wynn, had it not?
And Mr. Paul.
And Mr. Paul.
Yes.
So Mr. Paul tells you a deputy at the court that issued the warrant that I'm complaining about died under suspicious circumstances. That's what Mr. Paul tells you, right?
I don't remember those exact words, but it was something like that.
And maybe not that tone of voice, right?
Yes, sir.
But my point is, he actually led you to somebody that you in good faith interviewed, making you think that this husband might tell you suspicious circumstances of his deceased wife's death, correct?
Objection, leading and argumentative.
Is that correct?
Sustained.
Thank you. Now, my only point was you issued those 2. You served those 2, were they on the 29th to these 2 financial institutions?
Yes, sir.
And do you remember what the names of the 2 financial institutions were?
I don't recall. I don't recall.
All right. After you issued those subpoenas on the 29th, what happened?
I get back to Houston the following day, and I've received an email from, I think Microsoft at that point, and then also an email from counsel for one of the banks saying, we need some credentials to.
And of course, you had been saying all along to the Attorney General you wanted credentials, right?
Yes, sir.
In order to take care of this particular problem. Is that right?
Excuse me. Third time. Objection leading. Both questions.
Sustained.
Well, when you how many conversations did you say you'd had with the Attorney General trying to get credentials for this kind of work?
I think 4 or 5.
All right. And then once you got those emails, were those emails, if you served them on the 29th, were you receiving those the day after you served them, or would you receive them all the same day that you served them? If you remember.
It would have been after, and you can't quote me on that exact day if it was the 30th, but I do remember receiving emails to the effect of units.
And then what was the next thing that happened in your relationship, in your conduct with this?
I got a cease and desist letter.
From whom?
From a gentleman named Mark Penley.
What did you do?
I responded to his cease and desist and said, okay.
And then did you do anything else besides respond to it? Did you reach out to anyone?
I reached out to Mr. Paxton once I got the cease and desist.
Were you successful in reaching him? How did you reach out?
I believe I called him.
All right. Were you able to talk to him?
I don't remember if it was that, if I spoke with him that day.
Did you also get a visit from federal law enforcement?
I did get, the U.S. Marshals showed up at my office down in Houston.
Yeah. Do you remember what day that was?
Maybe October 1st.
Who was the first? Federal marshals were at your office?
They came by my office.
Who was the first person you contacted?
I called Mr. Paxton, blowing his phone up. Like, why are there U.S. Marshals at my office?
How many times you called him?
Probably 5, 6 times, text messaging, and he answered his phone.
On the 5th time?
One of the times.
All right. And how often were you calling him until you got him?
Well, my secretary comes back and says, there's U.S. Marshals here at the office, and I'm like, what? What's going on? And then I just start blowing his phone up until he answers it.
In your mind, certainly, had you done anything wrong that would merit anybody in law enforcement coming to see you, in your mind?
No, sir.
All right. So the first person you called was the Attorney General?
Yes, sir.
And when you got him, what did he say?
He told me don't talk to him without counsel.
So he told you to get a lawyer before you talked to them?
That's correct.
Okay. Did you talk about the merits or anything of why they were there? Do this. What did you say to him, and what did he say to you?
Yeah, I said there's U.S. Marshals at my office. What is this all about? And he told me, well, don't talk to him without a lawyer. I don't know what it's about either.
Okay.
And then hung up the phone.
He hung up the phone, or you hung up?
I don't remember. We both hung up the phone and went out there and greeted those gentlemen and went to my conference room, and I said, hey, with all due respect, I can't talk to you without having a lawyer present, but can I have a business card? And I got the business card from those 2 gentlemen, took a picture of it, and I sent it to Mr. Paxton. Said, these are the guys who showed up at my office, and that was that.
All right. What's the next thing that happened to you in connection with this?
I had sent my invoice back to Mr. I got a cease and desist letter, and I send my invoice back over, and then I get an email the following day from Jeff Mateer.
And what did Mr. Tier tell you?
They sent me another cease and desist letter, accusing me of crimes and all this other stuff. I'm like, whoa, what is going on here?
All right. And then at some time, did you go back to Mr. Vassar with the request to be paid, and that he responded to you?
They said there was no valid contract, and so I sent him the contract that I had for Mr. Paxton.
And all along, had you believed you had a valid contract?
Yes, sir.
And when you sent him the valid contract, was it signed? Who was it signed by?
It was signed by Mr. Paxton.
The one you sent back to him?
The one that they said that I didn't have a valid contract. I sent him the contract that I had for Mr. Paxton, with Mr. Paxton's signature on it.
Was Mr. Paxton's signature on the one you sent them?
The one that I sent them, I'm sorry.
When did you get a contract that had Mr. Paxton's signature?
I believe I got that on September 28th.
How had that happened?
So this was about the time that I'm getting ready to go with the subpoenas, and I still don't have my badge or credentials, and I was talking with Michael
I know.
Wynn about it, and I was kind of frustrated at the time, because I'm like, well, I'm supposed to go serve subpoenas and do this work. I don't even have my credentials, which my contract, don't have a badge, I don't have a governmental email address, and Mr. Wynn asked me, I guess, well, send me over your agreement. And I had planned on coming out to Austin the following day to come do these subpoenas. So I get out to Austin to go over to.
Now let's put a day on it. What day do you get to Austin?
That was on the 28th.
All right, the 28th would be a Monday.
September 28th.
All right. And you arrive in Austin on the 28th. And what happened when you got, who do you go to see?
I'm meeting over at Nate Paul's office, and Michael Wynn is there.
All right. And what do you find when you get there?
My contract was there on the table.
And was it signed by whom?
Myself and Mr. Paxton.
Had you ever seen a contract signed by Mr. Paxton before September the 28th?
No, sir.
And in fact, all this time that you thought you had a valid contract, did you have a contract that was only signed by you?
I sent Mr. Vassar my signed copy back on the 4th and said, please send me back an executed contract. And I never got one. I didn't know.
I just want to make sure real quickly here. You got back from you sent Mr. Vassar your contract, which had only your signature on the 4th. Is that right?
That's correct.
And then, from then until the 28th in Mr. Paul's office, did you ever see a contract that had the Attorney General's signature on it?
No, sir.
And when was it that you complained to the Attorney General, if you did, that you did not have a contract signed by him? When was the last time you did that before you saw it on the 28th?
I don't recall the exact date, but I had told him about a badge, credentials, and email address, and so I just never received it.
On the morning of the 28th before you left, did you have a conversation to go up there? Early in the morning, did you have a conversation with Mr. Wynn?
I did.
And what did you tell Mr. Wynn?
I believe he had texted me the night before and said, because I was frustrated, so I was telling him I don't have my credentials, like meaning my contract or my badge or any of that. So he texted me. I think I was already sleeping, and he said, "Send me your contract." So I wake up at like 5 in the morning, and I send it to him.
The contract you sent to Mr. Wynn early that morning,
About 5 a.m.
5 a.m., had only your contract, your signature?
Yes, sir.
All right. And then how soon after that was it that you arrived in Mr. Wynn's office where they had a contract signed by the Attorney General?
We went to Nate Paul's office, not
Okay.
Mr. Wynn's office, and we had to be around lunchtime maybe.
And you walked in and saw what?
My contract was there on the deal signed.
Signed by the Attorney General?
Yes, sir.
And that was the first time you'd ever seen one?
Yes, sir.
Signed by him. All right. Now, finally, when things got a little hectic for you after that, did they not, after the 29th and 30th of September?
Yes, sir.
When was the next time that you saw the Attorney General?
I don't remember the exact date. I'm sorry.
On the 29th or the 30th, did you see him? Or the 1st of October or the 2nd October or any of those dates? Did you have occasion to have contact with the Attorney General again?
I did. I just don't
When?
remember the exact date. It was after I had received the second cease and desist letter from Mr. Mateer.
And what were the circumstances of you seeing him?
I got a phone call from Michael Wynn, and he had said, hey, I need you to come out to Austin. It was like last minute, and it was in the evening. And I'm like, he's like, you need to come out to Austin and come over to Nate Paul's house.
What time
meet
of
us.
day were you supposed to get there?
I don't remember what time I got there. Maybe it was in the evening. My sun was going down.
All right. And so when you drove up there to Austin, to Mr. Paul's house, did you have any idea why you were there?
I mean, I figured because at this point, I've gotten a cease and desist letter. I've gotten basically the rug pulled out from under me. Like, I'm going and working, everything is okay. I'm getting affirmation that everything is good. And then all of a sudden, I've got cease and desist letters, U.S. Marshal showing up at my office. And I'm trying to figure out, how did we go from that to this? And I'm just trying to get answers about what's going on, because I still don't know. And so that's what I figured this was all about. So yeah, I get out to the house, I drive to Nate Paul's house, tell my fiance at the time, like, hey, I'm going out here, I'll be back later. And then, yeah, I get out.
So what happens when you walk in? Can you basically describe the meeting?
Yeah, I go in, and Michael Wynn is there, Nate Paul is there, and Mr. Paxton's there.
Where's Mr. Paxton, and what's he doing?
Shook his hand, and he was like on the phone, and then just spent most of the time just out on the balcony on the phone.
Was there anything surprising about him being there to you? Did you know he was going to be there?
I didn't know he would be there.
Pardon me?
I didn't know he was going to be there.
And then, what was the circumstance, the scene? How was everybody dressed? What was everybody doing? All that jazz.
I mean, I was dressed in a suit because I was, for business, and, they were dressed casually. I think Michael had a suit on. Mr. Paxton had like running shoes and running shorts on, or something, just casual.
Did they talk to you? Why were you there?
So while Mr. Paxton was out on the balcony, Michael Wynn and Nate Paul, they were just kind of commiserating about all this stuff that had happened in that last few days. And when Mr. Paxton came in, as I was going to leave, I think I was there maybe an hour, he had mentioned, that Mr. Penley didn't have any authority to tell me to stop working. He told him to stand down and just to continue to work on this report.
At that time, when you say he came in, was he outside the room but there when you arrived?
He was in the house and then went outside on the balcony or in the back and was on the phone the entire time.
All right, after Mr. Paxton told you that, how long were you there?
Oh, I mean, I left.
So what did you think? What was the meeting about?
Just a lot of talking about, how I can't believe that this happened. I can't believe what these guys are doing. The fact that Mr. Penley had reached out to Michael Wynn asking for documents, even though Mr. Paxton had told him not to work on the case, and this type of stuff. But I still left there like very, in my mind, I'm like, hey, I got 2 cease and desist letters, I'm not doing any more work. And I haven't been paid for anything, and so I'm just kind of listening, trying to get answers on what I should be doing.
So did you wonder on the way home why the hell you had been there?
Yeah, I mean, yes, sir. That was annoying to have to drive out a 3-hour drive for an hour meeting and then come back.
When is the next time you saw the Attorney General about this matter?
I think within the next couple of days, I got a call to come out to his office and meet with him and some of his staff.
And what did they want?
Mr. Paxton wanted me to meet Brent Webster.
Brent Webster was did you know who he was by that time?
No, sir.
Did you know what position he now had?
I knew when I got out there that he was, I guess, the first assistant.
And when and where did y'all meet? What did you do? Just walk us through it.
So we met in the conference room over at the Attorney General's office with 2 other individuals, and Mr. Paxton wanted me to just debrief what I had learned, what the first referral was about.
What did you tell him?
What I had done. I spent the first few minutes kind of just venting my frustration about how I felt like I had been treated to that point, still not having any clear answers. And, the fact that I had a whole entire life before of all of this, a docket. I had clients. I mean, I didn't ask for any of this. You guys reached out to me to come do a job, and then now you're pulling the rug out from under me, and I'm getting cease and desist letters, and now my name's being thrown through the mud in the media, and it's a totally new world to me. So, I let that out and just told them, what we kind of talked about here today, right now, that I'd issued subpoenas. I had this PowerPoint presentation where they showed me this, and
What did they say? What did he say? What did the Attorney General say?
I believe he asked me, or Brent Webster asked me, to send him any documents that I had sent the Attorney General, to email it to him.
Did the Attorney General apologize to you?
I don't think he apologized to me, no.
And then did y'all stay there, or did you go somewhere else?
No, I left there. Went back to Houston.
And then when was the next time that you saw the Attorney General?
Yeah, the next time, and I'm sorry, but I just don't recall the exact date, but it was within that week. I get a call from, that last meeting, it was like, hey, you need to, just continue to work on the report. Everything is fine. And in the back of my mind, I'm like, yeah, right, I'm not doing anything else. And then a few days go by, and I get a call to come back out and meet with him, just like a very short notice, maybe even the same day, to come out to Austin again.
You drove up again?
Drove up again.
You recall what that date is?
No, sir. It had to be the first week of October sometime, though.
All right. And then where did you go when you drove up?
I went to the AG's office again.
And then who was there?
Brent Webster and Mr. Paxton.
And what happened there?
I thought we were going to meet to talk about the contract and what is going on, and but instead, they were like, well, let's not meet here in the office, and they walked me over to a Starbucks outside of the office to have a meeting.
Did you ask why?
No, but it was uncomfortable. It was not professional to me at all.
So when you go to the Starbucks, who all's there?
Mr. Paxton, Brent Webster, and then a couple other gentlemen who I don't know.
And what happened at that meeting?
At that meeting, Mr. Webster did all the talking and told me, well, in fact, your contract is not any good anymore. Stop working, don't do anything at all. I asked him, okay, well, what about, paying me?
Do you recall exactly how you put it about whether you were going to get paid? Did you put the amount in there?
I think I ballparked it, and I said, what about my $14,000 invoice? And he's like, well, you're going to have to eat that invoice. I've had to eat $40,000 invoices.
Webster said he had eaten a $40,000.
That sticks out in my mind, sir.
Yeah.
Yes, sir.
Why does that stick out in your mind?
Just because it was offensive.
Yeah. What was the Attorney General doing during this whole conversation?
He was just listening in.
Did one of them tell you your contract was now terminated?
What Mr. Webster said.
How long did you were at the Starbucks?
15 minutes, 20 minutes tops.
Did you feel better knowing that Mr. Webster says he had eaten a $40,000 debt before? Did that make you feel any better?
I'm sorry, what do you mean?
How did it make you feel?
I don't know if I believed him or not, but I know it was offensive to me.
And then what happens? Anything you remember? What happened then?
Yeah, they left the Starbucks and tried to get in the car and drive off. I said, excuse me, can I get a ride back to my car?
So these guys take you to, are you saying that these guys took you over to a Starbucks outside the office, terminated your contract, told you weren't going to get paid, and then drove off, and if you hadn't said, wait, I got my car, they'd have left you in the street?
That's what it looked like.
Pass it away.
Mr. Cogdill.
Good Good afternoon, Mr. Kamek.
Hey, Mr. Cogdell.
We know each other distantly, I guess is the best way to put it.
Yes, sir.
You also know my associate, Mr. Oso.
Yes, sir.
Once upon a time, there was a lot of discussion in the court about young lawyers and five-year lawyers and whatever. At the time you got involved in the Paxton matter, Mr. Kamek, you were a five-year lawyer, right?
Yes, sir.
Mr. Oso, younger than you or older than you?
He's younger than me.
Let me begin sort of near the back and the marshals coming to your office. You learned eventually, did you not, that the purpose or the reason the marshals came to your office was because of the visit that you'd made to I guess, the widow or the widower at the clerk's office, right?
I learned that from my lawyer, Andy Drumheller.
Okay.
Yes.
And Mr. Paxton hadn't sent you to that clerk's office or anything of the sort, right? That
No,
was
sir.
That was Nate Paul. You met with Mr. Hardin how many times before you testified?
I've spoken with him 3 times.
When was the first time?
I believe it was in the last 2 weeks. I'm sorry, I don't remember the specific date.
About how long was that meeting, Brandon?
That was approximately 4 to 5 hours, I believe.
And the next time you met with him?
I met with him last week when I came out here. I thought I was going to be testifying on Friday.
And about how long was that?
Hour and a half to 2 hours.
And did you meet with him again last night?
Met with him last night for maybe an hour.
So that's a total of how many hours that you met with Mr. Hardin?
Roughly 7.
Could we see article of impeachment, article number 5? Have you studied, I assume you have not, Mr. Kamek, the articles of impeachment in this case?
No, sir, not studied them.
But if I suggested to you, this is, quote, why you're here, close quote, could you agree with me?
Yes, sir. I've read this. I've seen this.
All right. Did Mr. Hardin ask you or show you this article in any of those 8 or so hours?
I don't recall seeing this.
So in the 8 hours that you met with Hardin, he never showed you the relevant article that brings you here. So let's take it apart. It says, while holding office as Attorney General, Warren Kenneth Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro tem. Will you agree with me, Mr. Kamek, that you were not a prosecuting attorney pro tem? Agree with me on that?
Yes, sir.
Okay. It goes on to say that Paxton engaged Kamek, a licensed attorney, to conduct an investigation into a baseless complaint. Mr. Hardin never asked you about that? That language?
I'm sorry, could you
Sure.
rephrase that? I'm sorry.
Yes, sir, sure. Mr. Hardin never went over this language in the article of impeachment with you, right?
No, sir.
And you will agree with me, Mr. Kamek, that you certainly never believed that you were a part of an investigation into a baseless complaint, right?
No, sir, I did not.
Okay. 8 hours and you never asked that question by Mr. Hardin, right?
We didn't talk about a baseless complaint.
Okay. Let's go for strike 3, although you just need 1. It says, during which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. You would agree with me, Mr. Kamek, that was not your purpose. You were not there trying to benefit Nate Paul or his business entities. That's not why you agreed to get involved in this. Agreed?
Absolutely not. I didn't even know Nate Paul or his entities or anything like that.
Mr. Hardin has a reputation as not a good lawyer, a great lawyer, right?
Yes, sir.
Could you give us a reason why a lawyer as good as Mr. Hardin would have never asked you those critical questions?
In the words of a great American, Your Honor, it's calling for speculation.
Sustained.
Well, if that's a suggestion that I'm a great American, I'll take it. Let's go back. I think what may be lost in some of this, Mr. Kamek, is this is in the late summer or fall of 2020, right?
Yes, sir.
And this is when, I don't want to say COVID is raging, but COVID is ever-present, omniscient. It's taken over the world, right?
It's peak COVID. Yes, sir.
Peak COVID. So here you are, a younger lawyer. If I understand it correctly, you had just left, not too long before this, practice with your father, right?
That's correct.
He is also a criminal defense lawyer.
Yes, sir.
So you have your own practice, right?
Yes, sir.
You had tried a number of cases with your dad, I assume, a number of cases with others, right?
And myself, yes, sir.
And yourself. And you had tried, I guess, I'm assuming, anything from misdemeanor cases to felony cases,
Yes,
right?
sir.
You weren't some kid straight out of law school that couldn't find a courtroom door with a CNI dog and a search warrant. I mean, generally speaking, you knew what you were doing at the Harris County Courthouse, right?
Absolutely.
So along comes COVID, and like a lot of Americans, what you took for granted suddenly was an issue, right? Meaning your business, our business stopped. It didn't slow down. It came to a screeching halt, right?
Yes, sir.
Arrests went way down. Courthouses literally closed, right?
They did.
So you're rolling along, I assume, and you get a call from Mr. Wynn that the Attorney General might be calling you, right?
That's right.
Now, I assume you never aspired to be a prosecutor, or you would apply to the DA's office, but still, when the Attorney General calls, that's a big moment, right?
It was a big moment.
Okay.
Yes, sir.
You trusted Mr. Wynn, right?
I did.
He's a Harvard-educated lawyer. You were aware of that?
He's a serious lawyer.
He's a serious lawyer. And I assume that up to this point in time, Mr. Kamek, you didn't have any real personal connection in terms of going out and having drinks or having dinner or whatever with Mr. Kamek, but you knew him professionally slash socially, and you respected him, right?
With Michael Wynn.
Yes, sir.
Just an acquaintance who was part of a couple clubs I was, and we had worked on that COVID-19 panel with some of the district court and federal judges, and he seemed like a nice person.
Okay.
So,
He had a significant practice, at least from your perspective.
serious practice, yes.
So it's good news, and if I'm remembering your correctly, the call from Mr. Paxton or from General Paxton came on your birthday.
Yes, it was on my birthday.
You're thinking, what a great birthday present, right?
Something at the time I was like, oh, wow, what a coincidence.
And look at you now, Mr. Kamek. Didn't turn out to be that perfect, did it?
I never would have imagined in a million years getting that call to sitting in an impeachment hearing, sir.
Got it. So let's go completely sideways for a second. If there has been a suggestion, Mr. Kamek, that it is wrong or illegal to challenge or investigate the legality of a search, that is not your worldview, right?
I'm sorry, one more time.
Sure. If there has been a suggestion made in this courtroom before these 31 senators that it is somehow wrong or illegal to investigate the legality of a search or a search warrant, that is not your worldview. Agree with me?
I agree with that.
I mean, it's sort of born and bred in a criminal defense lawyer. That's part of what we do. You would agree with me?
That is what we do.
And any criminal defense lawyer, I think, that's been practicing longer than 6 weeks has probably challenged the legality of a search warrant. You would agree with me?
Yes, sir.
And has probably looked into the conduct of law enforcement agents in either the creation of a search warrant, right?
That's right.
The execution of a search warrant, right?
That's right.
Again, that's called Wednesday in our business. That's what we do.
That's a Wednesday on our business. Yep.
Now, would you also agree with me that not only do we have, I guess, the choice of challenging or investigating the legality of searches, but we have the obligation to do it on behalf of our clients, right?
Right, we're just on the other side of it.
Yes, sir.
That's right.
And if we don't do that on occasion, we can get sued by the client, right?
That's right.
We can have a grievance filed against us by the client, by the state bar, or someone else for failure to investigate that sort of claim, right?
That's right.
And I guess my long-winded point there is when you were asked by Ken Paxton, and we will get to that conversation, but when you were asked by Ken Paxton or told by Ken Paxton he wanted you to investigate the possibility of an illegal search or the creation of an illegal search warrant by agents, that was like, great. That's in my wheelhouse. That's what I do, right?
Well, it was an investigation into potential violations of the Texas Penal Code, which is what I'm familiar with doing. So it would be in my wheelhouse.
Right. So it's in your wheelhouse, in your strike zone, whatever, right?
Right.
And the fact that, oh my God, it's a federal agent, or oh my God, it's a federal magistrate. I mean, again, they deserve and are owed their deference, but there's nothing sacrosanct about an AUSA in our worldview, right?
I have complete respect for government officials, but, Mr. Paxton also believed that, hey, this is a serious accusation. It requires a serious focus. And, if someone's doing something like that, they should be held accountable for it.
And I assume, Mr. Kamek, you felt the same way.
I did feel that way.
Now, jumping ahead a little bit, but I think in one of the conversations, Mr. Kamek, you had, or one of the answers to one of Mr. Hardin's questions, that somewhere along the line you heard either Mr. Wynn, I believe, or Mr. Nate Paul say something, quote, and this is a statement attributable to Mark Penley, there's no amount of information that could be presented to him that would ever convince him that a federal official could commit a crime, right?
That's right.
And which person said that? Was it Mr. Paul that said that about Mr. Penley, or Mr. Wynn that said that about Mr. Penley, or do you know?
It was Mr. Paul said that.
Okay.
Mr. Wynn was there when he said that.
Okay. And that's just not the house that you live in.
I don't live in that house.
You don't feel that same way, right?
I don't feel that same way, no.
I'm assuming.
Excuse me, can the witness be a little closer to the mic and speak up a little bit?
All right, Judge.
I'm assuming, Mr. Kamek, that you view federal prosecutors and magistrates and judges just like defense lawyers, bankers, bakers, trash truck drivers, whatever. There are good ones out there, and there are bad ones out there.
Base people off of their character. I mean,
That's right.
That's it.
And you do not automatically foreclose from your mind or from your obligations an inquiry into the legality of a search warrant simply because it was signed off by a federal magistrate, right? That's a mouthful. There's nothing improper in your worldview about investigating a search warrant or the validity of a search warrant simply because it is signed off by a federal magistrate, right?
No, I mean, that's, as a defense lawyer, that's what we do, is challenge the validity of a search warrant. I mean, this was just on the other side of it, where that person could be held accountable for it.
Now, let's get to your first meeting with Ken Paxton. On your birthday, I think the 22nd, he calls, right?
Yes, sir.
And I'm sure you have been asked this question 287 times, but the best of your recollection, he says what to you when he calls you, Mr. Kamek?
I didn't speak with him that day. It wasn't until the 23rd that I spoke with him, and he said that he got my name from Michael Wynn. I think the words were, my name was dropped in a hat, and he got my name from Michael Wynn and wanted to see if I'd be interested in coming to talk to him about working on a criminal investigation.
And that would have been, if it's the day after your birthday, that would have been August 23rd?
Yes, sir.
And did he give you any detail about what he wanted to, what was the job description specifically that he wanted you to do?
Not at that time. It wasn't until I went out there and met with him in person that I found that out.
Okay, and if I'm recalling it correctly, there was some request by someone to bring a resume, right?
Yes, sir.
And it had been a while since you had a resume, right?
Yes, sir.
But you figured, well, if I've got to audition for the beauty contest, I'll find a swimsuit, I'll get a resume together, right?
Just trying to remain humble and do what he asked me to do.
Okay. And you met with him, right?
Yes, sir, on the 26th.
On the 26th, Mr. Paxton, General Paxton is, I mean, you knew him by sight, right?
Yes, sir.
He's gracious, professional, nice enough to you.
He was nice, yes.
And on that day, on the 26th, Mr. Kamek, can you share with us the description of what he wanted you to do?
At that time, he told me that he was looking to hire a special prosecutor to investigate whether, I guess, these federal agents had tampered with or altered a search warrant. Basically, violations of state law.
Okay. And again, we've talked about that's kind of in your wheelhouse.
Correct.
You spend 20, 30 minutes with General Paxton?
Probably 20, 25, something like that.
And he uses the phrase special prosecutor, right?
Correct. Yes, sir.
So we've heard that sort of go through the evolution of your story, but it is true that he was the person that first put those words into your mindset, right?
Yes, sir.
If I heard your testimony directly, then, Mr. Kamek, you go down the hall and you meet with Jeff Mateer, right?
Yes, sir.
And did he act like he knew why you were there?
He did.
And just collapse the conversation succinctly that you had with Mr. Mateer.
Yeah, so I had another copy of my resume. I handed it to him, and I said, well, it was kind of awkward for a second, just communicating with him, but he said, I said, you know, I'm here to interview about the special prosecutor position for this investigation with respect to the search warrant, and you know, he acknowledged that,
okay,
and said, oh yeah, you know, I know a little bit about that, and just kind of act disengaged.
Gotcha. And I think that was the phrase that you used with Mr. Hardin, disengaged, right?
Yes, sir.
But I guess my point, at least right here, Mr. Kamek, is the phrase special prosecutor was discussed with Jeff Mateer, right?
That's correct.
And at no time did Jeff Mateer say, oh, no, you're not going to be a special prosecutor. We can't hire special prosecutors. That never happened, right?
No, sir.
Did Mr. Mateer, disengaged as he was, did he ever indicate to you, Mr. Kamek, that there was no need for a special prosecutor being hired?
He did not.
did he ever indicate to you that he felt like this investigation was a baseless complaint?
His attitude was kind of like that, like he didn't feel like it was important or worth pursuing.
It didn't rise to his level of importance.
That's fair to say.
Okay. But he certainly never said or suggested to you that this was a crime or illegal for you to be interviewing for this job. Agree
He did
with me?
not. He did not.
Okay. Now, you don't get the thumbs up that day, but you leave. You're optimistic, hopeful about it, right?
That's right.
And to put us back in your worldview at the time, again, we're in the middle of COVID. Let me stop back. I over theatrically demonstrated or referred to how long you'd spent with Mr. Hardin. You and I did meet last night, right?
Yes, sir.
Spoke for 45 minutes or so.
About 45 minutes.
It was late, right?
It was late.
And it was after Mr. Hardin
I
had
met with Mr. Hardin, and then me and my lawyers came and talked to you for about 45 minutes.
Gotcha. So we have discussed this before. I'm not just getting lucky with every single answer.
We have talked about this, yes, sir.
Okay. So you're hopeful. Again, we got COVID. You're thinking the Attorney General. This is great. I believe that on your drive home, you call your grandmother, right?
I think I told you that. It's like,
did.
hey, I met the Attorney General.
Right.
Yeah.
And your grandma said, I guess would act like any other grandma. So good for you. That's awesome.
That was her attitude.
So you then go through a series of exchanges about whether or not you might have a conflict, right? Potential conflict with any other cases at the Attorney General's office.
Yes,
correct?
sir. Mr. Vassar at some point reached out to me about a contract.
Okay.
And told me that I needed to do a conflicts check.
Did Mr. Vassar ever suggest to you, Mr. Kamek, that you were unqualified?
No, sir.
Did Mr. Vassar ever express to you that hiring, whether we call you an outside counsel or special prosecutor, whatever, did he ever express to you that the hiring of you was unnecessary?
No, sir. He reached out to me to set up a phone call. And then on that phone call with him, I said, yeah, I'm interviewing, or he's calling me, I guess you're calling me about the special prosecutor position. And then he acknowledged that, asked for my email address, and I think we talked a little bit briefly about where he had gone to school and that type of thing. So he's, I told him the same thing that I told Mr. Mateer as well.
But he never gave you any pushback on the idea of you getting hired for this job, right?
I never got any pushback from anyone at the Attorney General's office until I got a cease and desist letter.
Say that again.
I never got any pushback from anyone at the Attorney General's office or the Travis County District Attorney's office or anything until I got a cease and desist letter.
In fact, Mr. Kamek, it's true, is it not, that in your, effort to be compliant, appropriate, righteous, that's probably overstating it, but in your effort to do the right thing, you called the State Bar of Texas Ethics Hotline and described what you were going through, right?
I did, sir.
And without getting into what they told you, you walked away from that conversation after explaining to the ethics hotline at the State Bar of Texas what you wanted to do. You felt like you had a blessing from the State Bar of Texas to do exactly what you do, right?
Told me congratulations on the job.
So in the middle of this alleged conspiratorial dark worldview effort, you're calling the State Bar just to make sure you are literally dotting your I and crossing your T.
That's
right?
correct.
Now, I think Mr. Hardin had you talk about your expectations about your sort of bell curve or what have you of ability. In other words, when you first met with Mr. Paxton, I think you thought, I can investigate, I can issue grand jury subpoenas, I can appear in front of a grand jury, I can make recommendations to the grand jury. Heck, I might even get to go try this case. That was kind of your worldview when you went into this, right?
I didn't think there would be any limitation all the way up into potentially presenting the case for a charging instrument, whether it be an indictment, a complaint, an information, or trying the case in front of a jury panel. So once I got my contract, then I realized how limited of a scope it was.
Yes, sir. You anticipated my next area question. Once you got the contract back, it was sort of the real world of, no, I'm not going to be presenting this case to a grand jury. No, I'm not going to be making recommendations. No, I'm not going to be trying the case, but I'm going to be investigating the case, right?
Yes, I was just still happy to be working for the Attorney General.
Got it. Now, and I don't know when you want to break, Mr. President.
I was going to go to about 3:10, about 15 more minutes.
That's fine. At some point along the way, you and General Paxton had a discussion about your hourly rate. You said $300 an hour, right?
Yes, sir.
And you would agree with me that all things being equal, that's a pretty reasonable, moderate rate, right?
Yes, sir.
I guess, Mr. Kamek, the more important than the money was sort of the prestige or the opportunity or the resume, if you will, of getting to work for the AG's office on this particular matter.
I thought it was a fair rate, and it was not about the money. And I have a whole business before all of this that I still have today. So it was not about the money. It was about trying to help out.
All right, so refresh my memory of when you get a contract from, and refresh my memory, I should know, but I don't. You got a contract from whom and on what date, the first contract you received?
I received a contract, this was my mistake, but the contract came in on September 3rd in my email, and Mr. Paxton asked me, did I receive it?
Okay.
But I didn't see it. It got lost in the shuffle of all the other emails. So I responded back and said, no, I didn't get it. And then Mr. Vassar resent it to me on September the 4th of 2020.
So you have a recollection of Vassar specifically sending you this contract, right?
I do, sir.
And when you received this contract from Mr. Vassar, you think that is an I mean, neither one of us are contract lawyers, but you think that's an offer, and by signing it and sending it back, you think that's an acceptance.
Yes, sir. I spoke with him, Mr. Vassar, about the contract.
Right.
I spoke with Mr. Paxton about the contract. He followed up to see if I got the contract.
Right.
He said he could get me the hourly rate. I told him I was coming back out there. I mean, to me, it was very clear that I was being hired for this position. And so I signed it and returned it to Mr. Vassar that day when I got home.
Gotcha. And no one suggested to you during that month of September that they had their fingers crossed and you really didn't have an agreement. In other words, you went through that month believing you had a valid contract with the state of Texas to be an outside lawyer, right?
Yes, sir.
Now, I think you told us that you, Mr. Kamek, attended a meeting with Nate Paul on September 4th, right?
Yes, sir, I did.
And that's here in Austin, right?
Yes, sir.
Let me back up. So Michael Wynn tells you, hey, the AG might be calling, the AG calls, right? And then you learn at some point that Michael Wynn not only had recommended you, but was Nate Paul's lawyer, who was the complainant, for lack of a better description, in this illegal search warrant claim, right?
Yes, sir.
Do you know when it was, Mr. Kamek, that you learned that Wynn was representing Nate Paul?
Yes, sir. It was once I got confirmation about the job, I guess, and
Okay.
I sent, Michael reached out to me and said to come meet with him and the complainant, Michael, or Nate Paul, on September 4th.
Now, Mr. Hardin asked you if you did any research about Nate Paul, or you Googled Nate Paul, or words to that effect, right?
He asked me that, yes, sir.
And when is the first time you have a recollection of doing that? Before you met with Paul or after you met with Paul?
Before I met with him, I just Googled him.
And you knew, obviously, at some point that he had a search warrant run on his home and his properties and his business and all of that, right?
Yes, sir.
You didn't come across news articles about that in your search, however long that was or wasn't, right?
No, sir.
But what you came across were articles where, for lack of a better description, he's the new golden child of commercial real estate in Austin. He's the new king or whatever, right?
It was just headlines about his career as a real estate developer.
From your perception, Mr. Kamek, you thought you were sitting in front of or meeting with a valid gentleman or person of substantial economic means, I guess.
I thought, okay, serious guy, businessman, serious lawyer, serious case. So it was to get very seriously.
Okay. So nothing about this, I guess I'm stumbling into, nothing about this was off-putting to you. You didn't think that there was, in fact, you thought this was, this case just keeps getting better and better for me, right?
I was just trying to focus on the facts of what I was being presented with. I didn't know any of these people.
Okay. So you meet with him in Austin. I believe you said you met with him for an hour and a half, 2 hours, right?
Yes, sir.
And I say him. Nate Paul is there. Michael Wynn is there, right?
Yes, sir.
Ken Paxton is not at this first meeting, if I understand it, correct?
No, sir. He was not there.
And they are explaining to you, that is Mr. Wynn and Mr. Paul are explaining to you their theory about why the search warrants may be invalid and why they might have been altered, right?
Yes, sir.
And I wasn't there, but as I understand it, Mr. Paul showed you, made a pretty convincing presentation utilizing a computer, diving into the metadata, which at least convinced you that this probably happened or this might have happened, right?
I was convinced.
You were convinced?
Something there.
Okay.
I didn't make a judgment either way, but it was a persuasive presentation.
How computer literate are you, Mr. Kamek? And that's a vague question. You know much about metadata?
No, I've never really worked with metadata in that way.
Okay, but it at least appeared to you at that time that Mr. Paul was literate in that area, made this explanation, made this explanation, and you accepted it, right?
Yes, sir. I was told that this presentation was also given to Mr. Penley and Mr. Maxwell as well. So it was just me, my set of eyes looking at it, and I thought it was persuasive.
And you leave there, I think, and go meet with Ken Paxton at his office here in Austin the same day.
Yes, sir, that's correct.
Do you recall how you described your worldview of the explanation that, I don't know why I can't talk. I'm paid to talk. You told Ken Paxton, I think, Mr. Kamek, words to the effect of, I think there may be something there, General.
I told him I was convinced, it was convincing what I was shown, and he agreed with that.
Okay. Now, let's go there. When you say it's convincing, exactly what words did you say?
I said it was convincing, it was persuasive, and he agreed with that. He said, yeah, I agree.
Paxton agreed with you.
Yes,
right?
sir.
Now, at no time, you would agree with me, I think, that did Paxton ever suggest to you that this investigation was a baseless investigation, right?
No, he never indicated that it was a baseless.
You believed, recognizing that you don't know what's in his head, but you believe that he believed the same thing that you believed, right?
Yes, sir.
At some point during this meeting with Ken Paxton, after you had met with Nate Paul, I think it is then that General Paxton says to you, get me a wet ink copy of the search warrant, right?
He said that after we got back from the press conference and I was getting ready to go.
That the same day?
Same day.
Okay, so.
He did say that.
And they probably understood it after Mr. Hardin explained it, but just so that I'll be on the same page with it, a wet ink copy is a copy that is actually signed with ink by a judge, right?
It would just be the original document.
And your understanding of why a wet ink copy was important is it could, if not definitively, then go a long way in establishing whether that warrant had been improperly altered or not, right?
Yes, sir, that was my understanding.
And the words of General Paxton to you, I think, were along the lines of, if you can find me a wet ink copy of this search warrant, that's all I need, game's over, right?
It was, if the wet ink copy is the same as the PDF document that was provided to Nate Paul and his lawyers, if they're the same, then it's over.
It's over, meaning he would be satisfied.
Would be satisfied with that. And if they were different, then obviously this thing's going to take a little longer to figure out.
Now, did General Paxton ever pressure you to find a given or a specific result?
With respect to my ultimate conclusions about what I thought happened?
Yes, sir.
No, he never pressured me one way or the other.
He didn't say, you got to do this, dude. I need one. I mean, if you get this done for me, you got a big job. I mean, there was never any suggestion of you engaging in any sort of impropriety or a request for any sort of impropriety on the part of General Paxton. Agree with me?
I agree with that.
Did he use verbiage like, look, I just want to know the truth. Just tell me find the truth in this thing. You remember that?
I do.
And when was it, Mr. Kamek, that General Paxton first told you, I just want to know the truth, or find the truth?
That would have been in our first meeting on August 26th when I first went out for the job interview.
So to be clear, before you were ever hired, that was his directive to you. I just want to know the truth. Find me the truth.
It was, yeah, I just want to know the truth, and if something happened, that would be an injustice.
Okay. Now, there has been a lot of discussion, Mr. Kamek, about evidence and what's not evidence and that sort of thing. At the time that you first met with Mr. Paul and Mr. Wynn, do you believe they gave you at least some type of evidence for you to begin an investigation in good faith based upon?
They gave me, they told me the story about what happened, and I took some handwritten notes, and then when I left there, I was given like this timeline of events to kind of, I guess, help me digest everything.
Okay. And so you set about doing what a lawyer should do. That is investigating, right?
That's right.
And you could have done a number of things in this investigation. I assume one of the things you could have done is knocked on doors and started interviewing people, right?
Yes, sir.
But you didn't do that, if I understand it correctly. Instead of knocking on doors, if I'm understanding what you did, you issued subpoenas or chose to have grand jury subpoenas issued, right?
Yes, sir.
Would you agree with me, Mr. Kamek, that the very intent and purpose of having the grand jury subpoenas issued was for you to be able to obtain that information without causing any alarm or concern on the part of the people of whom you were seeking the information?
That is correct.
All right. So for a week and a half, we have heard, oh my God, the grand jury subpoenas would intimidate these people and frighten these people and scare these people. It was exactly 180 degrees opposite from that. Your intention was to do the exactly opposite of that, right?
Can I explain that?
Yes, sir.
But yes, sir, to answer your question, when I spoke with Mr. Paxton about the idea of grand jury subpoenas, he said it was a smart idea because some of these individuals were people in positions of power, and this would be the most discreet way to get that information.
So if I'm understanding that conversation, then not only did you believe that was the most discreet way to obtain the information without alarming or frightening somebody, so did General Paxton, right?
Yes, sir.
Can we break now? Is that okay?
Members, we will stand at ease until 3:30, so a 25-minute break. You may resume, Mr. Cogdell.
Mr. Kamick, by my notes, I'm about halfway done, but let me see if I can speed this up and get you.
Mr. Cogdell, would you raise your mic up? There you go.
Yes, sir.
We had you talk a little bit, Mr. Kamick, about the grand jury subpoenas and the reason for that. At some point, I think I heard you discuss with my colleague, Mr. Hardin, that Paxton made a statement to the effect that he was being critical of Mr. Penley and Mr. Maxwell because they won't do any work. Do I recall that correctly?
I don't remember the exact question that was asked by
Okay.
Mr. Hardin.
Do you remember back during this time, that is back in September of 2020, that happening, that is Mr. Paxton being critical of Mr. Penley and Mr. Maxwell, believing that or stating that they didn't do any work?
Wasn't critical in the sense that like he gave me any detail about what they were or weren't doing. He just said that he couldn't get the people at his office to do what he was asking them to do.
Fair enough. Now, there are different ways of conducting an investigation. You'd agree with me?
Yes, sir.
There are all kinds of different tools that law enforcement can use, TCIC, NCIC, every initial in the book sort of stuff, right?
Yes, sir.
And even lay people can do computer searches, Google searches, Intellius, Truthfinder, LexisNexis, all that sort of stuff, right?
Yes, sir.
Are you literate on LexisNexis, or were you at the time?
Yes, but more proficient in Westlaw.
Okay. And Pacer, do you do much work on Pacer?
No, sir, but I'm familiar with it.
And Pacer is public access to computer electronic records, something like that?
I believe so.
Okay. May I approach, Your Honor?
Yes, you may. And the witness, if you can speak up, Mr. Kamick,
Yes, Judge.
make sure all of our senators can hear you.
Yes, sir.
Acoustics, not your fault, acoustics aren't the best. And some of our hearing collectively is not the best either, so. Hold on, get back to your microphone. There you go.
Yes. I'm showing you what's marked as AG Exhibit 1047. And I don't know that you've ever seen this, but I'm going to see if I can walk you through it. I would offer AG 1047, which is a docket sheet on the Contigo matter.
Any objection, Mr. Hardin? Sure.
If I may, please.
Take your time.
No objection.
No objection, admit to evidence, AG Exhibit 1047.
All right, Eric, if you could kind of blow up the top, and again, I'm just using you as my ventriloquist right now because I don't think you've ever seen this, or tell me if you have. Have you ever seen this before?
No, sir.
Eric, blow up the top of it, which says, obviously, the style of the case, which is Contigo Information Management. Are you familiar with that name, Contigo Information Management?
Yes, sir.
And that is one of the entities, is it not, Mr. Kamick, that Mr. Nate Paul was complaining that an illegal search may have potentially occurred at that place right there, Contigo, right?
Yes, sir.
Now, if you will go to the second page, Eric, of 1047. Let me go back to the first page, my bad. And on the first page, it shows, does it not, that Judge Mark Lane is the judge in this case, right? upper left-hand corner, Mr. Kamick?
Yes, sir.
That's obviously public information, and that Mr. Gupta with the U.S. Attorney's Office is representing the government, right?
Yes, sir.
So the whole world can see that based on anybody that has a Pacer account has access to that sort of information, right? Now, if you could go to the second page, Eric, and what that shows, give us the top half of that page. And what we see, do we not, Mr. Kamick, is there's a motion for leave to disclose sealed search warrant that was filed on September 5th, right?
Yes, sir.
And an order granting that motion for leave to disclose a sealed search warrant, right?
Yes, sir.
So that would allow, and that was granted on the 5th, and then it is closed again on the 17th, where someone files a motion to extend the sealing, right?
Yes, sir.
But for those, whatever that is, 12 days, that search warrant would have been the warrant, not the probable cause affidavit. And they probably understand by now, but I know you do. There's a difference between the search warrant and the search warrant affidavit, right?
That's right.
But the search warrant would have been visible via Pacer for those 12 days back in September. Again, anybody with a Pacer account could have logged in and looked at that at least during those 12 days. Agree with me?
It was not sealed during those 12 days.
Fair enough. Now, when you were working on this matter, did you ever see, Mr. Kamick, any evidence that Mr. Penley or Mr. Maxwell had done anything in terms of investigating the same complaints that you were investigating? Meaning, did you see any reports, any memoranda, any conclusion, anything?
No, sir.
It is possible, is it not? Let's say that I want to investigate whether or not a given prosecutor might have at least been accused in a pleading of doing something improper. You or I can get on Pacer and enter that person's name and pull up every case that lawyer's ever been assigned to, right?
Yes, sir.
And they can do the same to us as well, right?
That's correct.
But if we wanted to investigate whether or not a given prosecutor was doing something, we could look at their history, or at least their history that's visible on Pacer, right?
That's right.
Same with the judge, correct?
It should be public record.
Now, let me be Captain Obvious because it's a cape I wear a lot. Every single search warrant that is a bad search warrant was signed by a judge somewhere, wasn't it?
Theoretically speaking, it.
Okay.
Yes.
Well, I guess my point is, if someone is arguing, well, a judge signed it, therefore it must be good. Well, if it's a search warrant that was executed, chances are a judge signed it. That doesn't necessarily make it a good search warrant. It's just one more search warrant that one more judge signed. Agree with me?
I agree with that.
I think we heard you testify that Mr. Wynn, during, I guess, the latter part of September, stated that Penley had reached out to him out of the clear blue and asked for documents. You recall that?
Yes, sir. That's what I was told.
Do you know when, Mr. Kamick, ballpark that was?
It would have been, I believe, sometime in the fourth week of September 2020.
Okay, so if you were hired on September 4th, you had been working on this case for several weeks, or this investigation for several weeks by the time you heard that. Agree with me?
Sir, approximately 3 weeks.
Okay. Now, let's get into the time. Mr. Hardin had you walk through sort of the frequency of contact that you had with Mr. Paxton during this, and it was about a month. That's probably the easiest way to describe it, is about 30 days, right?
Yes, sir.
And Mr. Hardin had you describe your contacts with Agent Paxton, and I think you said, I don't know, 15 to 20 times, something like that, right?
Yes, I did say that.
And during that month or so period, you saw him a grand total of how many times face to face? 2 or 3?
Well, I can tell you the days. So the 26th was
Okay.
one time. September 4th was the second time.
Right?
Then there was the time at the end of September at Nate Paul's house.
That's 3.
And then there was another time when I drove out to meet with him and Brent Webster.
That's 4.
And then there was another time when we met at the Starbucks.
That's 5, right?
That's 5 times.
So let's use as a demarcation, artificial or not, I'm going to call it when the stuff hit the fan, and that is September 30th or October 1st, okay?
Oh, yes, sir.
So before the stuff hit the fan, and we're going to get to there, you had seen him a grand total of 3 times. That is Mr. Paxton, right?
2 times.
2 times, okay. Now, you said, I think in reference to a question by Mr. Hardin, that you had talked to him 7 to 10 times on the phone, something like that?
Yes, sir.
And there were some occasional texts as well, right?
Yes, sir.
Would you agree with me, generally speaking, Mr. Kamek, that those phone calls are generally short, to the point calls?
Yes, sir.
Do any of them stand out in your memory for one reason or another? That's not meant to be a trick question. That's just an open-ended question.
I'm just thinking about what stands out in my mind about the conversations.
Okay. Let me keep going, and if it comes to you, we'll come back to it.
Okay.
Fair? Would you agree with me, Mr. Kamek, that Mr. Paxton has, General Paxton, whatever we want to call him, has a, let's say, unique style of communication? I'm sure it's not exclusive to him, but what I mean by that is when he wants you, he reaches out to you and you're generally accessible, right?
Yes, sir.
But the reverse isn't always true. When you need him, it ain't always, he doesn't pick up the phone as quickly as you pick up the phone.
I would agree with that.
Okay. And you had 3 or 4 of these occasions where you were saying, look, Mr. Paxton, or look, General Paxton, I need an email address and I need some identification, or I need a badge or something, right?
Yes, sir.
And the response that you get is more or less, yeah, I'm working on it, yeah, right?
Yeah, I mean, every time that was kind of the
Fair
response
enough.
that I got.
And you would also agree with me that just about every time you're in the presence of General Paxton, he's either on the phone some of the time or on the phone all of the time. Is that fair?
The first 2 times that I met with him, he was not on the phone.
And those were the interview, right?
Interview, and then the second time that I went there.
Yes, sir.
And then after that, he was on the phone quite a bit.
In your mind, I think, not unlike perhaps others, he's kind of notorious for being on the phone when you need the man's attention. That's just how he rolls. Agree with me?
I didn't know him before
Okay.
all this.
I'm just talking about your experience with him.
Just figure he was busy.
And he is, as far as you know, right? Now, let's get to, speaking of busy, let's get to that point in time, Mr. Kamek, when you were asking for a signed contract and you told Michael Wynn you hadn't gotten a signed contract, and I think that was the night before, and then you roll into Mr. Paul's office the next morning, leaving at 5 or thereabouts, and lo and behold, there is a signed contract on the desk or at Nate Paul's office, right?
Yes, sir.
Do you know whether or not Mr. Kamek, that on that date that Mr. Paxton was out of town? You know one way or the other if he was?
No, sir.
Okay. Would you agree with me that based upon your observations of the man, he traveled frequently? Agreed?
There was at least one other time, that, yes, sir, that he said he was traveling.
Okay, so let's jump to the second, and again, I'm going to be quick running through these, but we've talked, generally speaking, about the first referral that you received from the Travis County DA's office, right? And that is the complaint about the search warrant.
Yes, sir.
Not too long after you're involved, you get this second complaint, right?
Yes, sir.
And that complaint is referred to you directly. It is mailed to your office, right? Somebody find that for me, a copy of it, the second complaint.
I believe it was emailed to me from Mr. Klimmer.
Okay, whether it was emailed or mailed, my mistake.
Yes, sir.
It was sent to you directly. Agree with me?
Yes, sir.
And if someone were to come in here and state that Travis County DA's office had no idea who you were or what you were doing and you were just some sort of ghost out there in space, you would disagree with that, would you not?
That would be a falsehood.
And in fact, Mr. Klimmer knew exactly who you were and where to find you, right?
Yes, sir.
And can you estimate for us, Mr. Kamek, how many touches, for lack of a better description, how many touches you had with employees of the Travis County DA's office? And when I say touches, I mean interfaces, emails, phone calls, personal visits. How many touches are we talking about?
Well, and it's no disrespect to the folks over there. I just don't remember everyone's name.
Of course
But
not.
when
I'm not giving you that pop quiz. I'm just asking to estimate it.
Yeah, so I spoke with one individual who referred me to Don Klimmer, and then I think there was another woman named Amy Meredith, maybe.
Okay.
And then I got referred to a woman named Bailey.
So that now we're up to 4, right?
I think we're at 4, and then from there were multiple
Repeat visits.
well, just back and forth on an email exchange about the subpoenas, and then 5 or 6 times there, like with Mrs. Molnar, and then I got that other referral from Mr. Klimmer directly.
So if we are counting each subpoena as a touch, we've got 35, 40 subpoenas?
Well, I sent them on the application, just multiple per, just sent them out. There were several emails to their office.
I'm interrupting you. I'm sorry. I apologize. But there were several tranches of subpoenas sent to the Travis County DA's office.
Yes, sir. I agree with that.
And there were several people you communicated with, right?
Yes, sir.
Some were staff and some were lawyers, right?
Yes, sir.
And at least in your mind, Mr. Kamek, they were well aware of who you were and what you were doing, right?
Yes, sir.
And you certainly never tried to hide that fact from anybody. When you were working with the Travis County DA's office, you told them who you were, you told them your job description, you told them what you need. It's not like you were hiding, right?
I was not hiding.
The second complaint is different, Mr. Kamek, in kind, is it not, from the first complaint? Meaning, the first complaint is, may I approach, Your Honor? And just to satisfy, the second complaint, correct?
Yes, sir. That's the second referral.
So again,
I'm sorry, Mr. Kamek, I really need for you to speak louder when you're answering, because I know.
Yes, Judge. That's the second referral.
And again, like the point I made before you saw the document, although I don't think there was a dispute about it, that was sent to you directly with your name on it, with your address on it. Clearly they know who you are, right?
Yes, sir.
Okay. Now, the first complaint again focused on the potential illegality of the search warrants. The second complaint focused on a alleged fraud concerning people trying to steal my words, not the complaint word, Nate Paul's property too cheaply, right?
Yes, sir.
And I believe, correct me if I'm wrong, but you utilized the resources of the Travis County DA's office to issue search warrants, or I'm sorry, grand jury subpoenas for the first complaint, correct?
Yes, sir.
And you did the same thing with the second complaint, meaning part of the thing that you did to investigate it was send out grand jury subpoenas to try to obtain information, correct?
Yes, sir.
Now, I think I heard you say, Mr. Kamek, correct me if I'm wrong, that you were not keeping General Paxton apprised of the names of the individuals that you had issued the grand jury subpoenas before, right?
I never spoke with him about like who specifically I was issuing subpoenas for, but that's not to say that I don't remember if I had forwarded an email list or something like that.
Fair enough. It's possible that you sent him on one or more occasions a list of folks that, or some sort of detail on names, right?
That's possible.
Not certain one way or the other if it happened, but it's certainly possible.
As I'm sitting here right now, I don't recall that.
Fair enough. But you didn't, in any conversation, as far as you can recall, Mr. Kamek, get so granular with General Paxton about the names of the people that were being subpoenaed that you said, well, Joe Smith on this day, Bob Hunt on that day, Travis Smith on the other. That didn't happen, right?
No, sir.
And I assume it is a safe bet to say that if you sent General Paxton an email containing a list with names on it, you don't know one way or the other whether or not he opened that email and read through it and assimilated or understood what was in it or not. Agree with me?
I'm sorry. Could you just rephrase that one for me?
That's a $500 question. I don't know why I ask it that way. You don't know if he ever opened up any email you sent to him and read it or not, right?
That's right. I don't know.
Okay. Now, in the in the investigation of the second complaint, did you think your marching orders from General Paxton had changed? Meaning, if I recall your testimony correctly, Mr. Kamek, in the first referral, he told you to go get the truth or find out the truth or whatever, right? I assume you were operating under the same belief system that General Paxton wanted you to do the same thing in the second complaint, correct?
That was my belief and my understanding.
And at any point, Mr. Kamek, that you were dealing with Ken Paxton, did he ever ask you to misrepresent anything?
No.
Did he ever ask you to, for lack of a better description, lie, cheat, or steal?
To lie, cheat, or steal?
Yes, sir.
No, sir.
And I'm including that in a broad sense, not in the literal sense. But also in the broad sense, not the literal sense, Mr. Kamek, never ask you to hide, secrete, destroy, never ask you to hide any record, conceal anything you did, dispose of anything that you obtained. There was never any suggestion of that, I don't think. Was there?
No, sir.
Now, there was the time when the stuff hit the fan, right?
Yes, sir.
And that was October 1st?
I believe it was October 1st, whatever day that I got a cease and desist letter from Mr. Penley.
Okay. And again, whether it's the 1st or the 2nd, 30th, whatever, you get the cease and desist letter, and what was your reaction when you got that? What was your thought?
I mean, I was shocked. I was confused and felt like a rug been pulled out from under me. And
I heard shocked and confused, and then I didn't hear the last thing that you said.
I just felt like the rug had been pulled out from under me.
Okay.
It just seemed like it came out of nowhere.
And it really did come out of nowhere, if I'm understanding your story, right?
It did come out of nowhere. I had never spoken with Mr. Penley over the course of those 3.5, 4 weeks.
And after Mr. Penley sent you that letter, Mr. Mateer sent you another letter, right?
That's correct.
And this is and he's basically saying, this is unauthorized, you're performing illegal activity, whatever. This is the very same Jeff Mateer whose office you sat in interviewing for the job that you took, right?
That's correct.
If I'm recalling it correctly, Mr. Kamek, when you got the first letter from the Penley letter, you responded very professionally, very appropriately, very succinctly. He sends you this cease and desist letter, and what do you reply back?
I think I told him that I would just stand down and something along those lines.
Unlike some other people that you might have heard of, you didn't get volcanic on him. You didn't pick up the phone and slur a bunch of invectives or worse at him, right?
No, that would have been unprofessional.
And to be fair to you, Mr. Kamek, all you were trying to do was do a job, do it well, do it professionally, right?
Yes, sir.
Then it gets even worse because the press starts blowing up, right?
Yes, sir.
And speaking for you, you are a 5-year lawyer, and you have authors, writers, people in the press that you've never spoken to, that you've never communicated with, that you've never heard of, just saying horrible things about you, right?
There were a lot of articles written, and I read a couple of them and then chose just to put that out of my scope of view, just move on with my life.
That was probably a wise decision. But it went into really needless detail about disagreements that you had with your family, and it just blowing everything out of proportion. And it was a nightmare for you, simply put, was it not?
It had nothing to do with anything involved with this. It was just a bunch of trash. I'm sorry.
That's all right. And it was, if you understand the timeline, or I guess if I understand the timeline, I'm asking you if you understand it the same way, Mr. Kamek, that by this point, the so-called whistleblowers had gone to the FBI, and that's when all this volcanic eruption occurred, right?
I'm sorry, could you?
Sure. When the negative press started coming out, it was after the time, at least insofar as what the articles were claiming, that several individuals that used to be with the Attorney General's office had gone and made a complaint with the FBI, or made the so-called whistleblower complaint. Is that consistent with your memory?
I remember reading, I think, about that.
And after this eruption, that is when you drive to Nate Paul's house, right?
Yes, sir.
And I mean, it's just a surreal time, fairly put, for you and for everybody else, right?
Yes, sir.
You go to his house, you had never been to his house before, you're hoping to resolve whatever issues are outstanding. Oh, by the way, you would like to get paid for your work, right?
Right.
And everybody's kind of standing around shell-shocked. When I say everybody, I mean you, Mr. Wynn, your your friend or whatever, Mr. Paul and Mr. Paxton, right?
Yeah, that's who was at that meeting.
And I mean, again, without engaging in hyperbole, it's kind of like everybody's sitting around with PTSD, just like, what the hell was that, right?
Right.
You were asked to continue the good fight, keep working, and in your own mind you say, no, I'm done with that.
No,
right?
That's right, I was done.
Okay. And then you have another occasion that you detailed for Mr. Hardin where Mr. Thank you. Mr. Webster and Mr. Paxton asked you to come to Austin. You come to Austin, and it's just as weird as as the time before. You don't go into the AG's office. You go over to Starbucks. Brent Webster says, 15 grand ain't nothing. I had to eat 40 grand. And you're thinking, that's not going to put, Post Toasties in my bowl here. I don't really care. My word's not yours, right?
That happened.
Okay. And to this day, you've never been paid anything, right?
$0.
Okay. And the reward that you have gotten is not really a good reward, right?
I haven't received any benefit from any of this.
Let me apologize for that situation.
Thank you.
That should have never happened.
Thanks.
Should have never happened. All that having been said, Mr. Kamek, it is still true, is it not, that what Ken Paxton asked you to do, find the truth?
That's what he told me when we first met. He just wanted to find out the truth about this first referral.
And that's what you were trying to do?
Yes, sir, that's correct.
I'll pass the witness.
Mr. Hardin, or redirect?
No, Your Honor.
Or both of you
You can be excused. Good luck,
finished with the
Mr.
witness?
Thank
You may be. Thank you, sir. Call your next witness.
Thank you, Mr. President. The House calls Joe Brown.
Bailiff, please bring in Joe Brown. Mr. Brown, if you'll raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth, so help me God. I do. Thank you. Please have a seat. And as they will instruct you, talk as closely to the mic as you can get. Thank you.
May I proceed, Mr. President?
Yes, you may.
Thank you. Sir, please introduce yourself to the honorable members of the Senate.
Joseph David Brown. I go by Joe.
Mr. Brown, how are you currently employed?
I have a private law practice in Sherman.
Could you please summarize for us, albeit briefly, your history as an attorney, your jobs, positions you've held?
I graduated from SMU Law School in 1995. I started with a civil law firm in Dallas, about 100 lawyers, Coles and Thompson. Did that work for about 5 years, returned to my hometown. Ran for district attorney in 2000 in Grayson County, was elected, spent 17 years as the district attorney in Grayson County, and then I was appointed as the Eastern District United States Attorney in 2018.
Was that a presidential appointment, Senate confirmation?
Nominated by the senators of Texas and presidentially appointed and Senate approved.
And under which administration were you appointed?
I was appointed by President Trump.
May I ask you, sir, at some point were you contacted by or on behalf of Attorney General Ken Paxton?
Yes, sir.
Can you tell us the substance of that?
I received a call in late August of 2020 from a friend in McKinney who was a mutual friend of the Attorney General. He told me that Attorney General Paxton would like to visit with me if I'd be willing to about a potential criminal special investigation.
Did you meet with with Mr. Paxton?
Within the hour, I received a call from Attorney General Paxton. He introduced himself, we visited a little bit, and he asked me if I would come to Austin to visit about a matter that he had. He did not give much detail at that point. I knew it was criminal, I knew it was a special investigation, but I didn't know the role really, and he said he would explain that to me if I came to Austin.
Did you go to Austin?
I came to Austin on August 27th of 2020.
Did you meet personally with Mr. Paxton?
I did in his office about 45 minutes, and I met about 15 minutes with Jeff Mateer.
Can you give us a summary? I'll ask you, did he provide you some information concerning this potential complaint?
Are you asking me to
Well, I'm asking you, did he give you information about the complaint?
Attorney General Paxton told me about the complaint, yes.
And if you could, in just a few words, tell me what the substance of the report was.
Well, I didn't know what role I would be playing, whether I was going to be an independent prosecutor or under the authority of the Attorney General. So we talked about that, but he told me it involved a guy that had a warrant executed, and he believed the warrant could have been possibly executed unlawfully. So we continued to visit about that and flesh that out.
On the information that he provided you, just off the top of your head, did you have any? Well, let me retract that. Did you ask of him whether or not he had individuals within his own office who might be able to investigate this matter?
Yes, we talked about the fact. I remember him talking about that it involved potentially a phone line cut on some execution of a search warrant, and the warrant affidavit being changed. And I learned during that meeting that it was involving the FBI and the Securities Board and DPS, and the investigation would be involving that. So yes, we talked about that, and he said he could not get the people in his office to do anything about it. And I talked a little bit more about that, and he talked about the ranger, the retired ranger that worked for him, that wouldn't do anything about it.
Let me stop you there. Did you ask him a question after he told you that his own people weren't getting work done on it?
Yeah, I said, why don't you fire him?
What was his response?
It was complicated, and it just didn't work that way.
Fair enough. Did he advise you whether or not there were any other people in the race, whether you had competition?
He told me that there was another lawyer, young lawyer, that he was considering, but that he didn't have the credentials that I did. And so I assumed that if I wanted that he would choose me to do that.
You said that he had identified, if I'm correct, the FBI, the State Securities Board, and DPS. Is that accurate?
I remember those entities.
Did those raise any concerns for you? Just that first question.
Yeah, as we're talking.
And let me stop you there, just so I don't get an objection. The answer to the question is yes, correct?
Yes.
Did you relay those concerns to Mr. Paxton, and if so, what did you say?
Yes, I was aware of the fact that his indictment involved those three agencies, and I said I have some concern about the fact that it would be involving, that I would be under your authority and investigating the same agencies that were involved in your indictment. As we talked about it, I eventually, I'm having to process this during this meeting and learn all this, and the red flags are going off. So eventually I say, my preference is that I would write a report and be able to evaluate these conflicts before I would commit to any level of prosecution. And he said, we have people that can prosecute the case, that would be fine.
From your recollection, did he appear affected by these concerns that you raised? Did he indicate that it was a problem?
I'm sorry, conjecture and speculation as to whether or not he was affected.
Your Honor, if I may.
Sustained. Yes, sir. Go
From what you observed, sir, did you have any personal observations for how you believed he took that news?
Same objection.
Your Honor, if I may, we're talking about a lay witness opinion. This individual was in the room with him and spoke directly with Mr. Paxton and can testify as to what he observed.
I will sustain. I think you can phrase it better, so try one more time.
Sounds like a challenge, Your Honor, and I'm up for it, I hope. You told him these concerns that you raised, is that correct? What did you observe, if anything?
He told me, when I said I'm concerned about these, he said, I understand, I'm not worried about that, I just want to find the truth.
Fair enough. Did he tell you, did he indicate to you whether the individual involved was a donor?
I did not learn he was a donor until I went to talk to Jeff Mateer.
Did you learn from Mr. Paxton that he had any other relationship with this individual?
No, I had no idea when I left the Attorney General that there was anything other than a guy that he was, that was wronged, and I was unclear on why it was going to a special prosecutor other than what he had told me.
So let's fast forward. At some point, do you speak with Mr. Vassar about a potential contract?
Within a few days, he made contact, Ryan Vassar made contact with me by email and eventually gave me a contract. It didn't have any specific terms, it was just a general contract, and we exchanged emails about the scope and some details of the contract.
What was your purpose in defining the scope?
I repeated what I had told to the Attorney General, that because of my concerns about the conflicts, I would commit to investigating, to writing a report, and would not commit to prosecution until I'd been able to evaluate the conflicts further.
Was there an hourly rate that was addressed?
The hourly rate was, I can't remember, it didn't come from me, it was suggested with a contract or by Mr. Vassar.
Would a rate of $300 an hour be accurate?
That was the rate that was given to me.
Did you have any concerns about that rate?
I was in 2 months out from the U.S. Attorney's Office and just starting, and this was giving me an opportunity to stay involved in something relevant. I mean, the Attorney General was asking me to help with an investigation, so it intrigued me, so I wasn't worried about the money.
You were prepared to do any sort of investigation if you cleared conflicts for $300 an hour, is that accurate?
What was described to me, yes. I mean, I knew I could, if I needed to, get out of it, I could.
Were you prepared to secure any insurance that was necessary as provided by the contract?
Well, the insurance thing didn't come up until, when I get the contract, it says you have to have malpractice insurance, and I was 2 months out of the U.S. Attorney's Office, so did not have it. But, it was not, that was not what kept me from doing it.
Did you, as a matter of fact, indicate to anybody that you were willing to get insurance within 30 days?
I would have gotten insurance if that was necessary. I thought it was something they could waive. And
did you explain that to Mr. Vassar?
Yes.
Did you feel, in your opinion, that in any way stood in the way of you getting the job if you were to be chosen?
Yep.
I'm sorry.
That would never...
Excuse me, Mr. Brown. Objection, conjecture, and speculation. He doesn't know if it's in getting his way or not.
You also can speak up, Mr. Cogdell, when you speak. Sustain, you can rephrase that.
Did you get a response when you indicated that you could get insurance within 30 days?
We emailed, and he said it was something that he thought they could take care of, or words to that effect.
Very good. After you have raised concerns to the General, Paxton, after you've indicated that you wanted to limit the scope of your work so that you could make sure that those conflicts and concerns were taken care of, after you've indicated that you would work for $300 an hour and get insurance, were you chosen?
No, I followed up a couple times with emails, and nothing happened after that.
Are you familiar with federal filings, or the process of performing federal filings as it relates to search warrants?
Yes.
You ran an entire office of Assistant United States Attorneys, correct?
Yes, I mean, I wasn't on the front line of the search warrants, but I certainly am familiar.
Fair enough. Are you familiar, sir, that when an application for a search warrant is filed, there is an application with accompanying affidavit?
Correct.
And then there is a search warrant order. Is that accurate?
Correct.
Okay. And what we would call the application and the warrant. Is that fair?
Right.
Ms. Manello, if you would please pull up AG 1047. I apologize, Your Honor, we didn't have a digital copy, so we're putting it on the Elmo. If you could look at line number 1, please. Would you agree with me that on August 16th, 2019, there is a motion to seal the search warrant application and the search warrant?
That's what's reflected.
And the search warrant application, again, contains the application and the affidavit. Is that accurate?
And the proposed warrant.
If we could go to line number 6 on the second page, please. At the top, would you agree with me here that it indicates that there is a motion for leave to disclose the search warrant, the sealed search warrant, correct?
That's the entry.
Would you agree with me that there is nothing on that entry that indicates that there is a motion for leave to disclose the sealed search warrant application, which would include the affidavit?
There's nothing that mentions the application.
Very good. Sir, are you familiar with OPR as it relates to federal government?
Yes.
Could you tell us what those initials stand for, please?
The Office of Professional Responsibility.
Do all Assistant United States Attorneys who enter on duty, at least during your time, are they made aware of the Office of Professional Responsibility and their jurisdiction to investigate complaints regarding United States attorneys?
Objection, conjecture, and speculation.
I'm asking from his direct knowledge, Your Honor.
Oh, you asked for
Overruled.
Please answer the question.
Assistant United States Attorneys are familiar with what the OPR is and what their jurisdiction is, yes.
If there was a complaint regarding an AUSA and the conduct in any one of their investigations, would the Office of Professional Responsibility be charged with investigating them?
Objection, conjecture, and speculation.
Overruled.
Please, sir.
That's one agency that could.
As a former United States attorney, presidentially appointed, are you aware if there is an OPR investigation ongoing, whether the United States Attorney's Office, where that employee who is complained of works, has any jurisdiction over the matter, or if it is entirely within Office of Professional Responsibility?
I'm sorry, objection vague. I don't understand the question.
Your Honor, if I may, I think it's more important if the witness understands it.
Overruled. You may answer.
I'm not sure I do, so.
That answers Mr. Cogdell's question. Would it be fair to say, or let me ask you this, in your experience as a presidentially appointed United States attorney, if somebody within your office, an AUSA within your office, was being investigated by the Office of Professional Responsibility, would your office, the office in which they worked, have any sort of responsibility for the investigation, or would it be entirely OPR?
No, my understanding is it goes to OPR out of Washington, D.C., and they keep it separate.
So the office where the AUSA works has no responsibility for that, correct?
That was my experience.
Are you familiar with OIG?
Yes, the Office of Inspector General.
Similarly, based on your experience working as a presidentially appointed United States attorney, are AUSAs within your office made aware of and trained on the Office of Inspector General and their jurisdiction?
They're certainly aware of it, what the level of training on it is. It doesn't take very long before they know that there's oversight organizations within the different areas of the Department of Justice.
If there is a complaint for an agent within the Department of Justice, not an AUSA anymore, but an agent, would the Office of Inspector General have oversight and jurisdiction?
It's my understanding they do. That's who investigates the investigators.
Same question. Investigates the investigators, and it is taken out of the hands of the regional or local United States Attorney's Office. Is that correct?
That's my understanding.
Thank you, sir. Pass the witness.
Thank you, Mr. Donnelly. Mr. Cogdell?
Hi, Mr. Brown.
Good afternoon.
I think we met?
We have.
Okay, in Sherman.
The courtroom in Sherman, yes, sir.
Lovely courtroom, lovely judge. Nice to see you again. When you were meeting with Mr. Mateer, Mr. Brown, did he tell you that this is a bogus investigation and it shouldn't be investigated?
No, sir.
Did he, that is Mr. Mateer, give any indication to you that the investigation or that the job that you were applying for was unnecessary?
No, I sensed a little, I sensed something, but he never said anything directly other than he was glad that I was being considered because I would tell the Attorney General the truth.
Okay. And same with Mr. Vassar. When you were communicating with Mr. Vassar about the details of the contracts, did he suggest in any shape, form, or fashion that the job that you were applying for was unneeded, unnecessary, a sham, anything of the sort?
No.
And I hear you, Mr. Brown, on the troubling fact, potentially troubling fact, that these are the same agencies or some of the same agencies that had charged Mr. Paxton with the state securities fraud case, which, by the way, do you know of your own personal knowledge if that thing is still pending after 8 years?
Objection, Your Honor, to the relevance as it relates to this witness.
Overruled.
Are you aware, Joe, that that case is still pending?
The case against the Attorney General?
Yes, sir.
Yes, I'm aware of that.
Okay. That was what was potentially troubling to you, right?
That was part of it.
Yes, sir. But not the allegations or the claim or whatever that the FBI or these different agencies had potentially engaged in misconduct. You were still willing to investigate it, right?
I left it open that could happen. I was willing to.
And you are the former United States Attorney for the Eastern District, right?
Yes, sir.
In fact, I think, and somebody said that the other applicant wasn't as qualified as you. Probably true, because there are very few people in the Eastern District that, on paper at least, would be more qualified than the former DA from Grayson County and the Eastern District United States Attorney, right?
That's your words.
Okay. In any event, you're a very qualified person. You weren't chosen, but you did make 2 or 3 calls trying to follow up to see if you could get the job. Am I recalling that correctly?
I was willing to do the job, and I didn't know what happened. Yes.
Okay. Fair enough. Thank you, Joe. Nice to see you.
Thank you.
No redirect, Your Honor.
Are both parties finished with the witness?
No problem.
Excused, Your Honor.
Okay, you're excused, Mr. Brown. Thank you, sir.
No,
Next witness.
Thank you, Mr. President. The House calls Kendall Garrison.
Bailiff, please bring in Kendall Garrison. Mr. Garrison, if you'll raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Please be seated and speak as closely to the microphone as you can. Thank you. Ms. Epley, you're a witness.
May I proceed? Please introduce yourself to the ladies and gentlemen of the Senate.
My name is Kendall Garrison.
Mr. Garrison, could you speak up a little for me? It's a big room.
My name is Kendall Garrison.
Thank you. And where do you work?
Amplify Credit Union.
What is your role at Amplify Credit Union?
I'm President and Chief Executive Officer.
As you might have heard, I want to go through this a little quickly, so I'm going to jump right in. I'm going to turn your attention to 2020. During that time frame, were you familiar with Nate Paul or World Class Holdings?
Yes.
How so?
Mr. Paul and World Class Holdings obtained loans from Amplify Credit Union.
Okay. And what was the status of those loans in the summer of 2020?
In the summer of 2020, we had issued a demand letter in as much as those loans were delinquent and were working their way toward foreclosure.
Okay. In the course of your employment, and does your staff create records specific to Amplify, their banking and their foreclosures?
Yes.
Have you provided those to the House?
I have.
Would it surprise you to know that we have provided copies to the defense?
It would not surprise me.
Did you provide a business record affidavit for those documents?
Yes.
And for the Senate, for Mr. President, that's been on record for over 14 days, the business records affidavit, and as such, I've provided a copy to defense, and I have a copy for the court. Mr. President, you'll notice I provided you an external document. I'll refer to that in a moment. In the meantime, the Exhibit 657 has been pre-admitted. Mr. Garrison, I would like to talk to you a little bit about those records. Do you remember 3 loans in particular related to Nate Paul in the summer of 2020?
I do.
And I'd like to move you forward to the end of July, early August of that year. What was the status at that point of those loans?
Those 3 loans had been posted for foreclosure.
And when you say posted for foreclosure, what does that mean?
That means we had requested a substitute trustee, and we had filed a notice with the various counties on where those 3 properties were located that we intended to foreclose on those on the first Tuesday of August.
Was Nate Paul aware of your intent to file and proceed with foreclosure?
He was aware.
Is documentation consistent with that provided in Exhibit 657?
Yes.
Now, after providing notice to Nate Paul, does he immediately file a bankruptcy?
He does not.
And just so that we're all aware, does the filing of a bankruptcy create a legal automatic stay foreclosing the ability to move forward with a foreclosure, for example?
The filing of a bankruptcy does create a stay.
Would we call that a nuclear option, though, for Mr. Paul?
Objection, leading, argumentative.
Sustained.
Does Mr. Paul make an effort to prevent foreclosure and avoid bankruptcy?
Objection calls for speculation as to Mr. Paul's intent.
If he knows, Your Honor, which he does.
I'll overrule. You can answer the question.
I'm sorry, can you repeat the question?
Yes, sir. So at the end of July, early August of 2020, does Mr. Paul make any efforts to avoid foreclosure and also avoid bankruptcy?
He had discussions with our staff, and his counsel had discussions with ours about options to avoid foreclosure.
Yes, sir. Stacy, if you would for me, would you pull up Exhibit 657, specifically .190? Can you see that? Excuse me. Can you see that, Mr. Garrison?
It's small, but I can see it. It's more legible now. Thank you.
And what does this appear to be?
Hang on a second. We don't have anything on our monitor.
We'll hold one moment. Ms. Epley, you said it was admitted. We do not have that on our sheet as being previously admitted. Did I mishear you?
It is possible, Your Honor, and I'm happy to lay a predicate right now. This is easily correctable.
Mr. President, I can't see anything. It's not on my screen. I don't know if the jury can see it. I hope you can, but I don't have anything on my monitor. Hopefully everybody can see here.
And, Your Honor,
Hold on one second. Hold on.
Sure.
Is it up now? You have it?
It is not.
Okay, hold on. Do the jurors have it? I have it. Can we have Damien, if you can take a look? We'll just pause there for a second.
Your Honor, could I ask that this not count towards my time?
Yes, ma'am, it won't count towards your time.
Thank you.
I'm getting a signal.
Jurors, are your monitors black now? Okay, they're all blank now, Damien.
It's up now, Mr. President.
Are we all
ahead.
go? And Your Honor, Mr. President, for the record, I want to ensure I'm getting confirmation that 657 was pre-admitted by agreement with defense. If, however, you would like me to lay a predicate, I can do that quickly.
That's not necessary. No objection.
Okay, we just didn't have it on our list, but
Thank you, Your Honor.
go ahead, and I will be sure you get a minute back. So there
Thank
you go.
you.
Okay.
Thank you. Now, Mr. Garrison, I'm going to draw your attention back to Exhibit 657 at page 190. Does this appear to be an email from Nate Paul?
It does.
And what's the date?
The date is August the 3rd of 2020, Monday, August 3rd.
Now, the senators and people viewing at home can read, so I want to move you directly to the link embedded in that email. Do you know what that is?
I do.
And what is it?
This was a link to an attorney general's opinion that we referred to internally as the midnight opinion.
Yes, sir, we refer to it the same, and I think the senators are familiar with the foreclosure letter or the midnight letter. Let me ask you, what was the impact of receiving that at Amplify Bank?
We had lots of discussions internally and with our counsel on how to proceed. This was highly unusual, and I am in my 44th year of banking, and this is the first time I've seen something of this nature. As a direct result of
Object
this,
to the narrative.
Sustained.
That's okay. I'd be happy to break it up. You mentioned that it's the first time you'd seen something like this, but to be fair, because I'm sure Mr. Little will ask, wasn't it in the middle of COVID?
it was,
So that's kind of unprecedented time anyway, correct?
in many ways.
So other than COVID, what was surprising about this?
It was surprising to see a ruling issued on a Sunday night or Sunday morning, I believe, maybe it was Monday morning, that essentially prohibited foreclosures in the state of Texas.
What's the impact of that for Amplify and for your resources and assets?
We had no choice other than to pull those bankruptcy filings. I'm sorry, those foreclosure filings.
Thank you. We've heard that no foreclosures in Texas were stopped because of the foreclosure letter. Is that your experience?
Objection. Objection. Leading.
Well, let me come back.
Sustain, re-ask, yes.
Yes, Mr. President. In that case, I've provided defense a copy of Exhibit 676. They received a copy of this over the weekend. It is external to the business record you already have. I'll approach the court.
Is there any objection, Mr. Little?
To 676?
Yes.
No objection.
Please enter 676 into evidence.
And Mr. Garrison, what is this?
This is an email from Ann Wynn to Brian Elliott, who was the in-house counsel for World Class.
You'd mentioned a moment ago that you had changed your course in regards to the foreclosure. Is that right?
That's correct.
What did you choose to do?
We chose to withdraw those foreclosure notices and not proceed with foreclosure on that Tuesday, the 4th of August.
On all three properties tied to Nate Paul.
Correct.
What was the value of the bank's assets in regards to those properties?
We had...
Objection. Vague.
Overrule.
We had loans outstanding to the world-class entities with Mr. Paul as a guarantor to the tune of about $11.5 million.
And were you receiving payment on that note?
We were not.
Hence the foreclosure, correct?
Correct.
And by forestalling or delaying that foreclosure, did it help make you money or cost you money?
It was a cost to us.
After delaying the foreclosure, did the bank sell the properties?
Can you ask that question again?
I sure can. So on August 4th, the properties were going to be foreclosed, but were not, correct?
Correct.
Did you maintain control of those notes?
We did maintain control of those notes for some period of time after that.
Okay. And then ultimately what happened?
Ultimately, on, I believe the date was September the 9th, we sold those 3 loans and assigned the deeds of trust to a third-party buyer.
And just to be clear, because of allegations made by Nate Paul's side of things, did you sell those at a great deficit? Did you lose money?
We did not. We essentially sold the loans at par, and we received our past due interest and some attorney's fees, as I recall.
So in regards to your dynamic with Nate Paul and foreclosures in August of 2020, who benefited from the foreclosure letter?
Nate
Objection, calls for speculation.
Overruled.
Thank you. I don't think we heard you. Can you repeat that?
Nate Paul and the world-class entities.
Pass the witness.
Mr. Little.
Mr. President, thank you.
Counselor, can we have just a moment?
Please.
Ms. Epley, could you come up, Mr. Little?
Happy to.
Yes, sir. Yes, sir.
George, if you can take your seats again, we are ready to resume.
Mr. President, if I may?
Yes.
All right. Mr. Garrison, in front of you, I think somewhere, did you get a thick pile of papers like I did from Ms. Epley? Is it in front of you over there somewhere?
No, I don't have any documentation before me in this moment.
I don't like working in 2-inch piles of paper, okay? I'm going to show you exactly what happened. We're going to go document by document, okay? Your Honor, may I approach the witness?
Yes, you may. You can start the clock again. It was a brief pause. Mr. Little. Thank you for helping to clarify, Ms. Epley.
Now, Mr. Garrison, interesting times during COVID as a banker. Yeah?
Without a doubt.
I'm sure your customers took out PPP loans. Yes?
They did.
And you were probably working that all from March forward. Yes?
We were.
With major clients of the bank, I'm sure. True?
Yes.
You had loans in workout from customers who couldn't transact as much business probably as they wanted to. True?
No.
You didn't have any loans in workout during COVID?
3.
3? 3 total for the bank.
Yes, sir.
All right, we're going to go one by one through them here in just a minute.
Okay.
You familiar with the CARES Act that prompted the PPP loans?
Objection, Mr. President. Relevance.
It's about to get real relevant.
I'm willing to let that question end, overruled.
Okay. You familiar with the CARES Act?
I am familiar in as much as I know it exists. I did not read it in its entirety.
There was an eviction moratorium, wasn't there?
Objection, providing facts not in evidence. He said he's not familiar with it.
Sustained.
Let me try again. Did you know there was an eviction moratorium under the CARES Act?
Yes.
Did you know there was a foreclosure moratorium under the CARES Act?
Yes.
Did you know that it went until July 30th of 2020?
I did not.
As the president or CEO of your bank, was you president or CEO or both?
Both.
As the president and CEO of the bank of Amplify Credit Union, why don't you tell, ladies and gentlemen of the jury, when the foreclosure moratorium ended under the CARES Act?
Objection, relevance.
Overruled.
If you would.
I don't know.
You don't know? Okay.
No.
Amplify wasn't Nate Paul Sr. lender or anything, was it? You had 3
Objection,
loans.
speculation.
Sustained.
Was Amplify Nate Paul Sr. lender?
Objection, speculation.
If you know.
He asked the question, overruled. You can answer.
We were with respect to these 3 properties.
3 special purpose entities that Mr. Paul set up, true?
Yes.
Okay. I want you to take a look at what's been marked as Exhibit AG 1031. And Your Honor, at this time, we move for admission in bulk of Exhibits AG 1031 through 1044.
Any objection?
Your Honor, I don't know. He has not provided me a copy.
I handed it to you, didn't I? Big stack right there.
Oh, I don't know.
Got a sticky note, it's purple. That's the ticket.
I
Ms.
stand
Epley.
corrected. Your Honor, or Mr. President, I think they're exact duplicate of what I've already provided. No objection.
Not quite. These are actually in chronological order. But no objection, right?
No objection, Ms. Epley?
No objection, Mr. President.
Mr. Arroyo, if you would.
Hold on 1 second. Let me
sorry.
submit them to evidence. AG 1031 to 1044, please. AG 1031 through 1044, please admit to evidence.
Mr. Arroyo, if you would. AG Exhibit 1031. Your lawyers are Streisand, Landon, Osborne, and Lemon, correct?
Yes.
And Steve Lemon is a partner in that law firm, correct?
His name's on the letterhead, so one would presume.
Yeah, and he was actually the lawyer representing the receiver in a separate Nate Paul case, correct?
Objection, speculation, and relevance.
Do you know?
Overruled.
I don't know.
You don't know. Okay. What's the date of this item here?
The date is May 27th of 2020.
Okay. And what is this document?
This is a notice of default and demand for payment.
Okay. At least as of May 27, 2020, the bank had hired, I'm referring to Amplify Credit Union as the bank. Is that okay with you?
Perfectly fine.
Great. The bank had hired an attorney, and it had hired an attorney to make a demand on WC Alamo Industrial Center LP and Nate Paul entity, true?
In this case, yes.
Mr. Arroyo, Exhibit 1032, please. Same thing with regard to WC 707 Cesar Chavez, yes?
Yes.
AG 1033, Mr. Arroyo. Same thing with regard to WC Custer Creek Center Property LLC, correct?
Yes.
All three of those entities are in default at the bank as of May 27 of 2020, right?
Yes.
So you posted them for foreclosure in July of 2020, right?
We would have had to post those.
Object not responsive.
Sustain. Answer the question.
So you posted them for foreclosure in July 2020, right?
Yes.
No, you never did you?
Then I object to relevance, Your Honor.
Did your bank post?
What? Overruled.
Did your bank post these three properties for foreclosure in July of 2020?
Objection, relevance.
Overruled.
Can you ask the question again?
Let me try for the fourth time. Did your bank post these three properties for foreclosure in July of 2020? Yes or no?
I don't know when we posted them for foreclosure, but they were posted for foreclosure.
That wasn't my question. And I believe the answer to my question is you don't know, right?
Then if that's my only choice, then I don't know when we posted them for foreclosure.
They weren't posted for foreclosure in July of 2020 because there was a foreclosure moratorium under the CARES Act, true?
I am not aware of that, how long that moratorium was actually in place. But if you want to foreclose on a property, you have to file a foreclosure, I believe, 21 days before the scheduled foreclosure date.
That's right.
So filing is not a foreclosure. It is the notice of intent to foreclose on the first Tuesday of every month as foreclosures take place in Texas.
And surely the bank wanted to get its money back through foreclosure as fast as possible, right?
Objection, argumentative.
Sustained.
Did the bank want to get its money back as fast as possible through foreclosure?
We wanted to receive repayment by whatever means necessary.
Very good. Mr. Arroyo, Exhibit AG 1034, if you would. Now, this is an affidavit of posting of a property for foreclosure, right?
It appears to be, yes.
And the date of this is July 10 of 2020, yes?
Yes.
And the entity that's being foreclosed upon is WC Custer Creek Center Property, LLC, yes?
Yes.
And that's in Plano, Texas, my neck of the woods, Collin County, Texas, right?
Yes.
So you posted this one on July 10th for August foreclosure, yes?
It appears to be that, yes.
Your testimony on direct was you posted all three of them for August foreclosure, correct?
That is my recollection.
That's not right, is it? Let's take a look at what's marked as Exhibit AG 1035. This is an email from Nate Paul to some people at the bank, yes?
It is.
And Nate Paul says, I'm writing to confirm you're aware of the attached announcement. Ms. Epley went through that with you, correct? Correct?
Can you ask that once again, please?
Ms. Epley went through this email with you, correct?
Yes, and I saw the email at the time.
Last sentence of that first paragraph, it says, in light of foregoing, please confirm before 5 p.m. today that you will not be attempting to proceed with a foreclosure tomorrow. A foreclosure tomorrow, not 3. True? That's what Nate Paul says in this email, right?
He does use the words a foreclosure.
And On Win responds the next day. That's House Board of Managers Exhibit 676 that was on the screen earlier. And she says, Brian, it is, and she's writing to Brian Elliott at World Class, it is our position that the restrictions cited in the unsigned informal guidance would not apply to our particular foreclosure sales. However, as a courtesy to borrowers and per your/their request, Amplify is willing to postpone the foreclosure sale to September 1, 2020, right?
I don't have that document on my screen, so I can't confirm or deny that's what it says.
Would you like to look at my copy?
Sure.
Mr. President, the House is willing to concede that the email written by them, his client, is in the singular.
It's a little late for your concessions. I'd like the witness to answer my question if I could, Mr. President.
Let him read it, and then you can repeat the question.
Thank you.
She does use the word "the."
Mr. Arroyo, Exhibit AG 1036, please. You didn't even notice the substitute trustee sale for WC 707 Cesar Chavez until August 7, after the AG's opinion was issued, correct? Correct?
I have a different recollection of those events.
Well, that's why we have documents, right?
I believe this was the second posting
Oh, really?
to make it for the September sale.
Do you have a document with you, perhaps, or in that massive pile of documents somewhere where your bank posted the other two properties for foreclosure in August?
I do not.
It seems kind of important-ish, isn't it? You don't have that, do you?
I do not have a document of that nature before me.
Well, in any event, we know for sure that there's an August 7 posting of that after the foreclosure sale, yes?
It appears to be a notice regarding substitute trustee sale, yes.
Exhibit AG 1037, if you would, Mr. Arroyo. WC Alamo Industrial Center also posted on August 7 of 2020 after the opinion was issued. True?
Yes.
Exhibit AG 1038, if you would. A separate notice regarding substitute trustee sale, August 7 of 2020 for WC Alamo. True?
Yes.
After the opinion, yes?
Yes.
And just to be clear for the ladies and gentlemen of the jury, and for the media who's gathering information on this, you told the media you had all three properties posted for foreclosure in August of 2020. And we read about it in the newspaper, true?
Yes.
In fact, not in evidence.
But you don't have...
Objection.
What is your objection?
Facts not in evidence, relevance, and counsel's testifying.
He just said yes.
Sustain the objection.
You told the media you had all three properties posted for foreclosure in August of 2020, correct?
I don't recall my exact words, but I did tell the media that we had those, that we had world-class properties posted for foreclosure, yes.
You don't have a document to prove the other two, do you?
No.
Show you what's marked as Exhibit AG 1039. This is the affidavit of posting for WC 707 Cesar Chavez, correct?
Yes.
Exhibit AG 1040, if you would, Mr. Arroyo. We're going fast, but I think you can keep up. Mr. Garrison, was it? We're at August 10 of 2020. It says notice regarding substitute trustee sale. This is for WC Custer Creek. True?
Yes.
You re-noticed it for the next month. Is that right?
Yes.
Tell the ladies and gentlemen of the jury, were any foreclosures being stopped in Collin County, Texas at this time?
I wouldn't have knowledge of that.
You don't know, do you?
No.
So when you testified on direct that for whatever reason, this opinion disrupted the business of foreclosing these properties at the bank, you don't really know whether Collin County stopped doing any foreclosures at all, do you?
Objection, asked and answered as to Collin County.
Overruled.
You don't know, right?
I only have knowledge of what Amplify Credit Union did in response to the midnight opinion.
That really wasn't my question, so let me try again. Do you know whether Collin County was doing foreclosures at this period of time or not?
I do not.
Mr. Arroyo, Exhibit AG 1041, if you would. And this is your affidavit of posting of WC Custer Creek Center property for foreclosure on August 10 of 2020, correct?
Yes.
Now, you sold all three notes, right?
We did.
So you didn't have to foreclose any of the three properties, correct?
Ultimately, we did not have to foreclose on any of the 3 properties.
And you didn't have to foreclose any of them because your bank lost $0. You sold all 3 notes, and your bank lost $0 as a result of whatever this informal legal guidance was, correct?
That is correct. We ultimately sold those notes.
And you didn't lose a single dollar. Just tell the jury.
We did not.
Why? Well, let's put our heads together. How did all 3 notes get sold at the same time? Doesn't that seem coincidental?
It was not a coincidence at all.
It wasn't a coincidence because Brian Hardiman is a man who his name may or may not have come up in this trial at some point. He put together 3 special purpose entities, and he had his agents come and buy these notes from your bank. Yes?
I have no idea. I know that the notes were purchased. I do not know who formed the special purpose entities. I only know who I interacted with.
Isn't it true that all 3 of these notes were sold to special purpose entities at Brian Hardiman?
I don't know.
Isn't it true this is the same Brian Hardiman who's the subject of the bid rigging investigation in Travis County District Attorney's Office referral number 2, and the same man who sent Ken Paxton a picture of a dead deer?
Objection, Your Honor.
I'm sorry,
Mr.
I'm not quite done
President,
yet.
no, absolutely not. Facts not in evidence, and absolutely staining someone who's not here without any basis.
Wasn't quite finished, but
Mr.
President.
Sustained.
Very well. Do you know who Brian Hardiman is?
I do not.
Who did you interact with on the sale of these 3 notes?
Justin Bain.
Justin Bain. Okay. So I guess what we would need to do if we wanted to see if there was any connection between Justin Bain and Brian Hardiman, we could just probably Google Justin Bain
Objection,
and
Your
Brian
Honor,
Hardiman,
if I
right?
could, Mr. President.
Sustained.
Thank you.
If you would, Mr. Arroyo, Exhibit AG 1042, please. Sold that note to somebody called Alamo Lanark, right?
Yes.
Justin Bain entity, B-A-Y-N-E, true?
Yes.
Didn't lose a dime, yes?
I'm sorry, say again?
The bank didn't lose a dime, right?
Right.
Exhibit AG 1043, if you would, Mr. Arroyo. Sold this note to something called Cesar Rainey Street LLC, right?
Yes.
Bank didn't lose a dime, right?
Right.
Justin Bain entity, B-A-Y-N-E, right?
Yes.
Exhibit AG 1044, please, Mr. Arroyo. Sold this note to something called Spring Custer LLC, and the bank didn't lose a dime, right?
Yes.
Justin Bain entity, B-A-Y-N-E, right?
Yes.
You've been in banking 44 years, did I hear that?
Yes.
That's a long time, right?
It is.
If somebody wanted to, I don't know, foreclose on a piece of property themselves and wipe out the existing owner's equity, this is probably a good place to start, isn't it?
Objection, Your Honor. The default has to occur first. He's implying things that aren't relevant.
Sustained.
No further questions.
Redirect, Ms. Epley.
No, Mr. President.
Do both of you excuse the witness? Mr. Little, excuse the witness?
He is, Mr. President.
Okay. You're excused. Thank you, sir.
Thank you.
And I believe this was the last noticed witness of the day, if I'm not mistaken. Sir? I
That's
am mistaken.
inaccurate.
I am mistaken.
Ms. Epley, who are you calling? Or Mr. DeGuerin? I'm not sure who's calling the witness.
Yes, Your Honor. The House Board of Managers calls Darren McCarty.
Bailiff will bring in Darren McCarty. Bailiff, just hold the witness outside for a moment. Mr. Busby, Mr. DeGuerin, I understand that both sides have agreed to exhibits. I guess that was earlier today, this morning.
That is correct, Your Honor.
And we're going to read those exhibits into the record now, correct?
That would be
Mr. DeGuerin?
Yes.
Both of you have agreed, okay? You may read these
Yes, Judge.
exhibit numbers.
I'm going to start.
Turn on the microphone. It's right behind the laptop there. There you go.
I'm going to start with the House Board of Managers exhibits first, Judge.
And read through them relatively slowly. Don't race through them.
Yes, Judge. House Board of Managers 55, 62, 77, 85, 86, 91, 92, 94, 324, 346, 657, 677, 678, 680, 681, 682, 683, 684, 685, 693, and 694. And Judge Attorney
You may continue.
And Judge Attorney General exhibit numbers 17, 33, 42, 47, 48, 84, 85, 141, 151, 155, 161, 165, 219, 223, 305, 307, 332 through 354, 371, 398 through 422, 428, and 429.
Thank you, sir. Mr. DeGuerin, hold on one moment. You may bring in the witness now.
No.
Please step over there, Mr. McCarty. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Please be seated. And is that stack of papers there from the last witness?
It must be.
Okay, let me pick those up. And as closely as you can speak on the microphone, you might want to raise that. You're a little taller, just a little bit. There you go. Mr. DeGuerin, your witness.
Mr. McCarty, we've had trouble with the sound in here, so please get close to the microphone.
Absolutely.
And tell the senators your name, please.
My name is Darren McCarty.
And what is your occupation?
I'm a lawyer.
Give us the benefit of a brief statement of your training and experience.
After law school, I clerked for Karen Williams on the United States Federal Court of Appeals, the Fourth Circuit. After that, I went to work for Gibson, Dunn & Crutcher in Dallas. I did do a couple of stints at smaller firms and sort of finished my original stint in private practice at Alston & Bird, Dallas office. Actually helped found that office. And then after that, I came to the Attorney General's office.
What year did you come to the, month and year did you come to the Attorney General's office?
I believe it was maybe late April, early May of 17.
And how did you get that job?
Jeff Mateer, he was the first assistant at the time, was somebody that I had known, I had met actually working as an intern for Congressman Dick Armey in DC when we were both quite young. I think I was 17 or 18 years old, and I think Jeff was a couple of years older than that. We lost touch over time, but got reacquainted because we were both doing pro bono work on religious freedom cases. Sort of kept up our friendship, et cetera. And when he took the job here, he initially approached me. I initially declined because I just had a lot of things going on at the time. I couldn't move to Austin. But then eventually, maybe 6-8 months later, recontacted him, or he recontacted me, something like that.
And when did you first meet Ken Paxton?
When I was interviewing.
And did General Paxton interview you himself?
He did.
Okay. It may not matter, but are you a Rhino, a Republican in name only?
Well, no, I wouldn't say that. I think I started out when I was in 8th grade of my own volition, hanging door hangers for Ronald Reagan, and was a youth delegate of the Republican National Convention. I took a semester off of college to help staff a congressional campaign. It was actually the last campaign of a Republican against Jim Wright before he stepped down from his congressional office. And then, I continued working sort of in politics while I was at the University of Texas. I think I was the press secretary for the University Republicans, and it's what I've been for a long time.
Okay, could we have the organizational chart up, please? I want to put on the screen in front of you and in front of the senators the organizational chart of the Office of the Attorney General. Highlighted to the far right of the chart is your name and photograph. What was your role in the year of 2020 in the Attorney General's office?
I was a Deputy Attorney General for Civil Litigation. In that role, I oversaw all of the civil litigation for the office. I think it was 12 divisions, roughly 325 attorneys, and I think total personnel somewhere north of 600.
Among those duties, among those responsibilities, was the charitable trust division within your purview?
Yes, it was the Financial Litigation and Charitable Trust Division.
And briefly, what is the Attorney General's role statutorily with regard to charitable trusts, charitable foundations?
Very briefly, the Attorney General sort of has broad powers to protect the public interest in charity.
The public interest in a charity, does that sometime include protecting a charity from attacks from without?
Absolutely.
And does it sometimes include protecting a charity from itself, from mismanagement?
Yeah, from breaches of fiduciary duties, some sort of mismanagement, yes.
Is there a requirement under Texas law that when a lawsuit involving a charity occurs that the Attorney General is to get notice of that lawsuit?
Yes.
What does the Attorney General do then? What does your charitable trust division do then when given notice?
They look at the lawsuit and do some investigation to determine whether the charity is qualified to protect itself and is protecting itself. In other words, if there's some sort of mismanagement issue at the charity, or there's some inability to legally represent itself, the charity in the litigation, that might be a place where the Attorney General's office steps in to protect the charity.
Give us a rough estimate of how many charitable trusts exist in the state of Texas, if you know.
I do not. Quite a number.
Is it in the hundreds of thousands?
That would not surprise me.
Okay.
Yes,
And
but
give
I don't
us
know.
a rough estimate, if you will, of how many times the Attorney General's office, let's say in a year, involves itself in some way in a charitable trust litigation.
It's a handful.
A handful.
At most.
Okay.
So it may be, again, it may be a management problem. Sometimes charitable trusts, are falling into a state where they sort of can't be self-sustaining anymore, et cetera. And so, the AG's office will get involved, but it's not a common occurrence.
What procedure does the Attorney General's office go through to determine whether to involve itself in litigation involving a charitable trust?
Well, first, the Financial Litigation and Charitable Trust Division, as it was organized then, they have a group, obviously, within that looks at charitable trusts. So they analyze the situation. They make, the staff attorney will make a recommendation, I think initially to the head of the charitable trust group within the division, as to whether to intervene or not. And then that's sort of, if it's a non-intervention, typically it sort of stops at the division level. It won't necessarily come up to me unless they think it's a close call and they would need someone in my role's advice. If that's not the case and they believe that they should intervene in the case, then there would be an executive approval memorandum, and that would be signed off on. That would be signed off by the division chief. It would be signed off by me. I believe it would have been signed off by the Deputy First Assistant Attorney General and also by the First Assistant.
I want to ask you some questions about the Mitty Foundation and some litigation involving the Mitty Foundation and Nate Paul or World Class Holdings. You're familiar now with that litigation, aren't you?
Of course, yes.
We do not have an agreement on Exhibit 54, but I'm going to hand you Exhibit 54 and ask that it be introduced once he identifies it, Your Honor.
Thank you.
Any objections from the?
No, Your Honor. We'll allow this.
We'll admit Exhibit 054 into evidence.
Will you pull that up, please? I want to direct your attention to the first paragraph of this memo. First, what is the memo?
This looks like a memorandum that recommends, I shouldn't say it looks like, it is a recommendation by...
Keep your voice up and get close to the microphone.
I'm sorry, I was busy trying to read this. This appears to be the memorandum that
I'm sorry, it is on the screen if that's easier for you.
Okay, that is easier, thank you. This is the memorandum that declined to involve, for the AG's office to become involved with the Mitty Foundation. So this would have been prepared at the division level, and highly unlikely that it would have come to me initially.
All right. I want to draw your attention to the first paragraph, and I'll just read it as you look at it. If you'll highlight that first paragraph. I recommend waiving the Attorney General's interest in this matter regarding a private real estate company's breach of fiduciary duties to its investors, one of which is a charitable trust, the Mitty Foundation. Did I read that correctly?
You did.
And that's a memoranda recommending to waive the Attorney General's interest.
That's correct.
On the second side of that letter, if you go to the second page, I want to highlight the paragraph in the middle, in my opinion, starting there.
I see that.
This office does not have a role in this matter. The trust is zealously represented by counsel. Counsel stated that once the receiver sells the First and Trinity LP and WC Third and Congress LP, the trust will likely make a massive return on its investment. Did I read that correctly?
You did.
And finally, at the bottom, I recommend the Attorney General file a waiver for the following reasons. The trust is represented by counsel, the trust's assets are diversified, and the litigation will not critically impact the trust's 2020 distributions. Is that right?
Yes, that's how it reads.
Following this, did the Attorney General waive waive interfering in this lawsuit?
Yes, we did not intervene in January or around that time frame in 2020.
Pull up Exhibit 55, please. I believe this is agreed. Entered by agreement. This is the Attorney General's waiver, isn't it? Filed in the lawsuit, styled the Mitty Foundation against WC and Trinity, so forth, the world-class, or Nate Paul's organizations.
That's correct.
I want to highlight at the bottom of that first page of the waiver, if any pleading is filed herein that adds additional parties or causes of action, then that would constitute new or additional proceeding, and then the Attorney General might intervene, correct?
That's correct.
Did any new parties, additional parties, or additional causes of actions ever get filed in that case?
I certainly don't recall any new parties, and I was not aware of any additional causes of action.
Did General Paxton order that an intervention be made?
Well, yes.
Let me ask you this way. Did you have a conversation with General Paxton in which he expressed his request or order that the intervention be made?
Yes, I did. So General Paxton eventually came to me, and this was my first involvement with this case, substantive involvement, right? There are 34,000 matters.
Okay. So let me get it this way.
Yeah.
Was this on your radar screen at first?
No.
How did it get on your radar screen?
It got on my radar screen because General Paxton particularly wanted to intervene in this matter. I don't think my first discussion about this matter was with General Paxton. I think it was probably with Jeff Mateer. But at some point soon thereafter, I had a meeting with General Paxton, and he expressed a high level of interest and some insistence that we should intervene in this matter.
In your experience, had General Paxton ever expressed interest in any litigation involving charitable trusts that the Attorney General was involved in?
Objection, Your Honor, that's speculation.
Sustained.
Had there been any other litigation involving charitable trusts that you'd had any conversations with General Paxton about?
I did not.
I'm sorry, I didn't hear you.
There were not, no. I had no other conversations about any other charitable
So what was your thought about General Paxton getting involved in this litigation?
I did think it was unusual at the time.
I'm sorry?
I did believe that was unusual at the time. And that's probably all I thought about it at the time. We had so much going on in my divisions at that time with COVID and the Google lawsuit, et cetera. I did not spend a great deal of time thinking about it other than sort of a mental note that was a little bit, that was out of the ordinary.
All right. So at any rate, did the Attorney General's office file an intervention in that lawsuit?
We did.
At the time it was filed, do you rely on advice from your staff of attorneys that generally have hands-on handling of the litigation for advice?
Of course, I always
If we could have the
sought advice for them.
organization chart again, please. Down the list of people under you, there is a Joshua Godby. Who is he?
Your Honor, I'm sorry, Mr. DeGuerin. Our screen shows the previous document. I'm not sure why that is.
I think you've got a glitch over there.
Clearly.
We have the correct.
I can tell the court reporter does, but for some reason our table has something completely different. And I'm not trying to take away your time. I'm not trying to take the man's time.
We'll pause the clock for a moment.
Literally just our table.
It's just our table that keeps doing this. I'm not suggesting a conspiracy, Your Honor. I'm just saying it's happening.
Are the rest of the tables of your attorneys have the right screen? Damien will come to the rescue.
Okay.
It looks like the senators have the right one. I'd request an extra 15 minutes for this delay.
I bet you could negotiate him down to 1.
We've given you 6 more minutes today, so plus we saved you 5, so you're 11 minutes to the good.
Mine's still just frozen up.
Mr. DeGuerin. Mr. DeGuerin. Busby. Members, we're going to take this is the last witness of the day, but there's still more questions and cross. So let's take just a quick 10-minute break here, not our normal longer break, and then we may be finished by a little earlier this evening. So 10 minutes, come back at 20 minutes before the hour of 6.
Mr. President? Oh. Okay.